My lord,
All the list.
my lord, may I pray for leave to file this writ application on urgent basis because
No leave is necessary.
Well-
You indicate the date. On that date, it will come.
my lord, what happened in this manner? 3 days are taking in filing section. That's why.
No, nothing is necessary. So far, this court is concerned.
Well,
on
I know.
presentation.
That's why I never disturb your lordship, my lord. It is taking 3 days for giving the final number.
File it, file it, file it. Yes.
My lord, this matter was directed to appear on
Today is not the mentioning date. Mention on Monday. Unless until you cannot wait for up to next Monday.
matter inclusion in the list, my lord. I could not able to appear due to my health.
Yes.
Inclusion in the list, my lord.
Inclusion in the list. Today is not the date for mentioning. Inclusion for what? Is a hearing matter or motion?
Motion, my lord.
Motion of which year?
2025, my lord.
2025. Very well, ma'am. It will appear in the monthly list of January 2026 under the heading motion. Serve notice upon other side. Call the list.
Deeply obliged, my lord.
Item number 1.
Lord, I am appearing on behalf of the state, my lord. On the last occasion, your lordship was
Yes.
yes, well, the report is in favor of the petitioner. The thyroid function is normal and anatomy is also normal.
Yes. Who is for the Union of India? He has been declared absolutely normal so far enlargement of thyroid report is concerned by the board of SSKM.
May kindly have a look over this judgment of this appointments of this honorable court lordship.
Union of India.
Hemoglobin, percentage of hemoglobin in blood, that is the matter, that is the issue in this order you are relying upon, that can be corrected or that can be improved by medication. But enlargement of thyroid cannot be improved by medication within a very short span of time. So therefore, a court directed that that it is to be the petitioner is to be re-examined by the medical experts of SSKM hospital, and what they have stated that blood test for thyroid function, for physiological function of thyroid gland was found to be absolutely normal. Ultrasonography of thyroid, size of thyroid glands normal and not enlarged. Sorry. Esho.
May I permit to give a copy of
Yes,
it?
sir.
Yes. Give a copy of this
Yes, sir.
report. In terms of the order dated 4th November 2025, a report prepared by the medical board
দিয়েছি ওরা মানলেন না
of SSKM hospital, prepared by the medical board, SSKM hospital, IPGME and R and SSKM Center of Excellence or SSKM hospital, dated 24th November 2025, enclosed to the letter dated 26 November 2025 of Medical Superintendent cum Vice Principal IPG MER-SSKM Hospital, Kolkata, is placed before this court and same is taken on record. Next paragraph. Issue which needs to be addressed by this court is whether petitioner is to be adjudged medically fit or not for his selection for the post of Constable GD under Central Armed Police Forces within bracket CAPFS, close bracket. Petitioner has made out a case that though he was declared medically not fit by the concerned respondent authority in review medical test, when since he was found to have been suffering from enlarged thyroid stop সেন্টেন্সটা পড়ো তো enlarged thyroid কেটে দাও stop enlarged thyroid but medical expert of government medical college. No, but a professor department of ENT of a government medical college and hospital. It was Arjikor Medical College.
No.
This medical college. Previously, you have annexed the report.
Yes.
Arjikor?
No.
Medical college and hospital, Kolkata.
Calcutta Medical.
Kolkata
Calcutta
Medical
Medical
College.
Page 19.
But now, Department of ENT Medical College and Hospital, Kolkata, opined that petitioner was not suffering from enlarged thyroid. Based on such medical report, dated 12th October 2024, petitioner prayed for direction to declare him medically fit for his selection for the post of constable G. Next paragraph. Previously, on hearing the learned advocates representing the parties and taking note of two divergent views expressed by medical experts, this court found it fit to refer the petitioner to an independent medical expert for medical examination in order to find out whether petitioner is suffering from enlarged thyroid or not. Stop. Accordingly, video order dated 4th November 2025 concerned Department of SSKM Hospital, Kolkata, was directed to medically examine the petitioner and submit a report. From the medical report, which is submitted today, dated 24th of November 2025,
Summary portion.
it is found that petitioner is not suffering from enlarged thyroid. Stop. Relevant part of the medical report is quoted below. কোনো এই জায়গাটা কোট করে দেব। এই জায়গাটা কোট করে দেব। Next paragraph. However, learned advocate representing Union of India has placed reliance upon the order dated 16 November 2023, passed by a coordinate bench on a writ petition being WPA 20911 of 2023, within bracket Kaushik Gayan versus Union of India and others, in order to substantiate the case of the respondents that petitioner is not medically fit. Stop. On perusal of stop. Ratio of Kaushik Gayan Supra relates to low hemoglobin level in the blood of the candidate, based on which in review medical examination petitioner was found to be not fit. Stop. In the backdrop of such fact, it was observed by the coordinate bench that medical condition of the candidate at the time of examination is relevant for the authorities to consider suitability. Stop. However, ratio of Kaushik Gayan Supra does not come in aid of the respondents, since the issue was low hemoglobin level in the blood of the petitioner, which is not an issue in the present case, as the petitioner in this writ petition was found to have been suffering from enlarged thyroid, which cannot be improved within a short period of time by medication. Stop. Hemoglobin level in the blood can be improved by appropriate diet and medication. Stop. Next paragraph. In view of aforesaid, in aforesaid conspectus, concerned respondent authorities are directed to treat the petitioner medically fit and consider appointment of the petitioner for the post of Constable GD in CAPFS if petitioner is found to be otherwise eligible. Stop. Writ petition stands disposed of. Urgent xerox certificate. Right.
Item number 2.
For the petition in this matter.
I am for the NDPC matter led by Mr. Majumdar matter, Somo Majumdar matter.
If you should kindly see Lordship's last order, my lord.
Just
Reason your lordship directed us to file a report, my lord. A report not yet been prepared, my lord, due to some circumstances, my lord. My lord, I have received a statement. The amount has been due, and at nomination form, my lord. This is the form, my lord.
a minute. Let me go through my own order.
আগে একটু দেবে না একটু দেখে আসেন বলো
এক্ষুনি পেয়েছি আমি, আমার লোক ছিল না বলে আছে। এটা তোমাকে দেওয়া আছে, তাও দেখো তোমার
নমিনি করে গেছি না।
Prepare a report.
Kindly give me, this is the due, my lord, the table of the,
Very well, court directed to file a report, issue. In terms of the order dated 12 November 2025. Now, in terms, client advocate representing NTPC Limited has prayed for extension of time to file report in terms of the order dated 12 November 2025. Stop. Time to file a report stands extended by 7 days. Stop. List the matter under the same heading for further consideration on 16 December 2025. Take it back. Take it back.
Item number 3.
Lord, I appear for the State Fisheries Development Corporation Limited. Come for the question. Last question is also directed to submit the deposit that I have submitted. Lordship.
Yes. Have you deposited deficit court fees? Yes.
The second round of litigation, Lordship. We are the delegated worker, Lordship. Till 2023, we have been working, but no wages has been paid till date.
Where you are working?
Under the State Fishery Development Corporation, Lordship. I have been engaged in, can you see the page number 26?
No wages are being paid.
Lordship. I have been challenged that, Lordship, and this is second round.
In the any order has been passed by authority.
Lordship.
Page 133.
124 is the 133. Lordship. That is a reason order, Lordship. 128 it starts. No, High Court order. Page 125, Lordship, the previous High Court order.
Eight.
Can you see?
Just a minute. যে প্রথম যে জাজমেন্টটা করলেন কনসপেক্টাসের আগে একটা লেখা একটা Show me that you are still working.
So kindly see the Lordship, last attendance sheet, Lordship, that is page 29. March 2025, till date have been.
It's an official, official
Yeah,
attendance.
No, your Lordship, this
Attendance
attendance sheet,
maintained by them.
attendance sheet maintained by them, your Lordship.
Lordship,
And
can
Lordship
see the
will requisition, let her complete, madam. Kindly see the requisition, Lordship. Requisition salary, Lordship.
Yes, yes.
Requisition salary, Lordship. Kindly page 82, Lordship. The project in charge sent to the managing director for the salary, Lordship. In the month of March 2023, to Lordship,
Now you are getting wages. No.
after April, Lordship, I'm getting.
After April 2025, you are getting. So for which period wage
March-
is not paid?
March 2023 to April 2025.
Very.
Every month,
Admit the reputation for file your affidavits.
Lordship,
Because,
There's
there
the
are
interim measure, Lordship.
documents
Lordship,
which goes to show that the petitioner is still working.
well, two things. Well, first,
That's why your director has directed in the impugned order that all project in charge are hereby directed to strictly comply with the instructions.
The project in charge are not being made a party, they ought to have been made a party because they were a necessary party in the hearing, because upon perusal of all the documents which has been provided by the project in charge, the order has been passed. And page number 26,
Still they are working, they are getting wages from
the-
April 2025.
it is not a continuous period of work. The work is project wise. If your lordship kindly turns to page number 26, your lordship will
And the
see
salary requisition of fund of net amount rupees so and so
every month.
for payment of daily wages for the month of March 2023 issued by project in charge.
Second page, that is why I'm
That is within
submitting.
the disputed period.
That is what I am submitting. The project in charge ought to have been made a party in order to show what they have produced before us when the authority has conducted the hearing. And
Whether your director has heard project in charge.
yes, your lordship, that is
Heard.
my instruction. Yes, they were
When is the
present.
recording that project in charge was heard?
If my lord kindly turns to the impugned,
Page 129 rescind order.
yes, lordship. My lord will see at page number 131, based upon records submitted by the PICs, the revenue generated from the relevant project is as follows. The project in charge were there and they were also heard.
Where? Page 131.
Page 131, lordship, number 5, the revenue position. Your lordship will see.
No, that is a document submitted. That
Document
does not mean
submitted.
that the project in charge was present at the time of
The
hearing.
the instruction that I
Showing
have.
that the project in charge appeared personally before the director of fisheries, managing director, State Fisheries Development Corporation.
Lordship. My lord will also see page number 129, that it starts from number 2, my lord, it starts pursuant to
When
the
your project in charge has issued these documents relating to salary receipts or wage receipts or wage slips. So therefore, project in charge be concerned, project in charge be made party and let there be direction for filing a
lordship.
Filing affidavits.
Yes,
Directing to file affidavit.
yes. Because it depends upon appreciation of facts.
Lordship.
They are saying they did not work. You will say you are saying petitioners are contending no, they are working and now they are working and getting salary. getting wages. So why they were not paid for the period from 2023 to 2025? Because it is stated that they did not work at the material point of touch.
Only like injustice, I'm saying that these people are very
Did
poor.
not render any identifiable tangible services.
Impossible not only fixes a date, matter. Impossible.
Affidavit service আগে দিল।
না ঠিক আছে
Affidavit of service.
dispute করছে তো
Yes, affidavit of service. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph, document in support of putting in deficit court fee is also taken on record. Next paragraph, in the writ petition, order dated 12 June 2025, issued by the managing director, State Fisheries, the State Fisheries Development Corporation Limited is under challenge, whereby prayer of the petitioners to release area and wage for the period from March 2023 to April 2025 has been refused.
টাকা দিচ্ছে না কেন
বলছে তো কাজ করেন
Stop.
রিপোর্ট ফাইল করতে
It is recorded in the order. It is recorded in the order in the impugned order dated 12 June 2025 that petitioners did not render service at the material point of time. Next paragraph. On perusing the impugned order dated 12 June 2025, court finds that the issue needs to be decided on exchange of affidavits. Next, however, learned advocate representing the state respondent submits that
Malaram only for the
concerned
SFDCL.
project concerned
PIC. Malad, I'm not representing the state, Malad. I'm only representing the SFDCL, Malad.
FDC. আচ্ছা ওখানটা চেঞ্জ করো learned advocate representing the State Fisheries Development Corporation Limited or limited কি বলছিলাম সেন্টেন্সটা so and so the State Fisheries Development Corporation Limited has submitted that project that concerned project in charge needs to be added as a respondent who, according to the petitioners, took steps for release of wages. Next paragraph. Let affidavit in opposition to this writ petition be filed by 1 week after Christmas vacation. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate way.
for wages না order দিচ্ছেন কি
petitioners to amend the cost title and add a project in charge Krishno Bath Fisheries Project, Bishnupur, Bakura as additional respondent in course of this day. Stop. After such amendment is carried out, learned advocate for the petitioners is directed to serve copy of the writ petition, copy of the amended writ petition and the order passed today by 7 days from date and file affidavit of service on the next day.
would it be possible to fix as a date? These are daily wage roulette.
Next.
Grateful judge.
Item number 4.
This is my petition, my lord. The matter, my lord, after sudden demise of her husband.
Just a minute.
Yes, my lord.
Yes.
Lordship, I'm for the Eastern Coalfields Limited. Lordship, in this matter, there has been some suppression of material facts. The fact is like this, Your Lordship. The deceased employee was dismissed for unauthorized absence in the year 2007. Subsequently,
in the year 2021
Dismissed.
for unauthorized absence. I have got the papers, I have got the documents with me. Subsequently, Your Lordship, what happened? The deceased employee, after his demise in 2021, from 2007 to 2021, there was no iota of agitation on the part of the petitioner. In 2021, certainly, the petitioner, wife of the deceased employee, places an application before the Horipur Colliery, thereby seeking or ventilating the grievance that the petitioner is not getting the pension and the other retirement terminal benefits. Now, first of all, he was dismissed on 2007. Secondly, this particular colliery got closed in 2016. That paper also, Lordship, I have. Subsequently, Your Lordship, the record shows that regarding the Provident Fund and the pensions, we have already disbursed or contributed the amount to the Provident Fund Authority till 2007. Whatever his legitimate claim is till 2007.
What are the benefits which are payable to the petitioner?
Payable to the petitioner, Your Lordship, according to me, Your Lordship, as per instruction is the Provident Fund and the gratuity, as well as the pension. But
Pension petitioner is entitled, family pension petitioner is entitled to get.
Yes, ma'am.
but the point is still from 2000, whatever is from 2007, not from 2020. What my learned friend is canvassing, there has been a huge delay.
Case of dismissal, that will not entail future disqualification in getting employment.
Lordship, employment is not the subject matter in the present case.
Yes, that is known to this court. So dismissal from service is a mere dismissal, or it's a future disqualification to get further employment in any other organization.
It was a bad dismissal. Bad dismissal. Lordship, to that effect, Your Lordship.
So therefore, petitioner, being the wife of the dismissed employee, is entitled to get the Provident Fund, then gratuity as well as family pension.
LCSM.
Treating the reckoning the date in 2007.
Lordship, to that effect, Lordship, if my Lord permits me, may be permitted to file a short affidavit.
Benefits are not paid.
Lordship, Provident Fund and the gratuity.
What about the gratuity and
gratuity and Provident Fund, my Lord, my learned senior friend is appearing on behalf of the Provident Fund Authority. He will be the best person to answer.
That is payable after 2007.
Immediately after those, because record shows
in 2025, already 18 years have passed.
Lordship, record shows we have contributed. What prompted them not to pay?
What about family pension?
Pension also, as far as the pension scheme, it is the Provident Fund Authority only who will disburse the pension.
Why these are not paid?
We have not received any claim till 20th November. It may be deposited till 20th November. Despite repeated communications, we have not received any claim from this petition.
Is there any provision to make separate claims? So,
yes,
Lordship, they have to. Lordship, to that effect, may be permitted to file a short affidavit just indicating the facts on record, Your Lordship.
By 7 days.
Let us receive the claim by tomorrow. We shall disburse.
Court is directing you to release the amount by 7 days. Petitioner has approached this court with the writ petition that nothing has been paid.
It is the responsibility of the employer to forward the claim to us. We are merely the disbursing authority. The amount as well as the claim should be forwarded to us.
Lordship, we have already forwarded all these. The record shows that we have already.
Show him that it is forwarded.
Lordship,
maybe contributed Provident Fund is regular. It is getting contributed regularly, but the thing is, this claim has to be made.
Claim has to be made.
That person has died. He has retired superannuated. So let his Provident Fund, pension, whatever, may be released. So
yes,
claim should be forwarded.
Not a case of retirement.
Death.
It's a removal from service.
Removal from
2007.
Right.
So from after 2007, that employee was entitled to get those
whatever
benefits.
It may be.
Those benefits were not paid.
Please
don't open your mouth too wide. You will be in soup.
Lordship,
Enough is enough.
We always pay interest.
Petitioner's husband was removed from service from 2007.
Yes.
And it is the submission on behalf of Eastern Coalfield Limited that the petitioner's husband was entitled to receive benefits from 2007-8 onwards.
Yes.
These are not paid. So within 7 days, release benefits with appropriate interest.
We always pay interest till the date of payment. That is not the factor.
Very well.
But let us receive the claim.
When you are paying?
Until we receive the claim, our hands are tight. Let the respondent number 7. 7 is the concerned colliery. They are supposed to forward the claim.
Colliery has been closed.
Then ECL, It is
Colliery was closed
Is-
from
it is the
2016.
sister concern of ECL, that concern colliery. It is the sister
Very
of
well,
ECL.
you send another claim by 48 hours.
Let us say, yes,
Lordship,
48 hours. We are
this
discussing.
this amount is to be disbursed by the Provident Fund Authority to
We shall
petitioner.
discuss, we shall discuss.
So,
Will not enter into this issue, madam. It's a chemistry in between Eastern Coalfield Limited
Right.
and the Provident Fund Organization. But court wants to see that the petitioner can see the color of money
Lordship, we can intimate the Provident Fund Authority.
within 48 hours.
Yes.
Within 48 hours, he will intimate the
Claim,
payment. That the
claim should be
payment.
for it. Claim.
Please wait.
Lordship.
Payments are required to be made,
Hmm.
and within 7 days thereafter, he will release entire amount
We shall
along
release.
with 8% interest from the date when the petitioner was, when the husband of the petitioner was entitled to get the benefits till the date of release.
Even we pay higher interest.
Yes.
Hmm.
So how much interest you are
We
proposing?
we provide them the calculation sheet. There is always a calculation sheet. We pay interest till the date of payment, till the date of disbursal of the money. But let
By
us have the
48
claim
hours,
first.
you intimate the claim of the petitioner,
Uh.
entitlement of the petitioner to get the benefits. That is Provident Fund, gratuity, and
Gratuity is the controlling of the different respondent. Respondent number
Only
10.
pension and provident fund.
Have you
Respondent,
received gratuity?
No.
respondent number 10 is yet to appear. They are not appearing. They serve notice upon
Gratuity is to be paid by the
controlling authority. Yes. We don't pay the gratuity.
So
Gratuity.
why it has not been paid?
Lordship, we have
It has
disbursed.
not been intimated.
Lordship, after
Similar thing, what Mr. Go Thakurata is submitting. You must not have show me that when it was intimated that that the gratuity is required to be paid.
Lordship, the gratuity and the Provident Fund, whatever our owners was to just to deposit the amount to the respective departments, respective
You are
organizations.
saying that it was intimated, claim was forwarded, but Provident Fund Organization is saying no, it was not forwarded.
We will file towards so far as the
A
Provident Fund.
similar thing happened in case of gratuity.
My lord, might have been, my lord. But the situation is like this, your lordship. We can intimate to the Provident Fund Authority within 2 to 3 days, my lord,
Who
3
is
days.
the authority to
It
release
should be
gratuity?
prescribed for.
Controlling authority, respondent number 10,
9 and
9, 9,
8 and 9.
8 and 9.
No, no, 8 to আমরা।
9.
9, my lord. Controlling authority.
Colliery was closed and nothing was, no steps were taken.
Lordship, no step was taken on the part of the petitioner also.
This is Coal Mine Provident Fund Organization. Mr. Go Thakurata is appearing respondent number 8.
8.
Controlling authority under the payment of who appears for the controlling authority payment of gratuity act?
Lordship, I am not aware that.
I have already served. I have already
না, control কে যেন দাঁড়ায়?
controlling
Who
authority.
appears Mr. Go Thakurata for
No, no,
controlling
controlling
authority
authority
payment of
does.
gratuity?
Lordship?
Who appears for controlling authority payment?
Well,
of
my
gratuity?
Lynette Fenn is
No, no,
appearing.
I did not appear on behalf of control authority. Somebody else appears.
Petitioner can serve another notice, your lordship, if my lord pleases.
No, no, already it has been served. It's not an old writ petition. 7 November 2025 filing. Issue.
Lordship, if my lord permits me, I can file a short affidavit. If
No,
I,
no,
because
not
placing the
required.
petition record.
Sorry. First make payment. Learned advocate representing Eastern Coalfield Limited on instruction submitted that husband of the petitioner was an employee of Eastern Coalfield Limited or ECL within bracket for short ECL was dismissed from service in 2007. Therefore, benefits towards Provident Fund and Provident Fund, gratuity and pension were payable to the employee or his wife after his death. Considering service of the petition at least 2007, not beyond that. Next paragraph. Regional, next paragraph, regional Coal Mines Provident Fund Organization being respondent number 8 is represented by Mr. Go Thakurata who submits that claim of the petitioner was not forwarded by the concerned authority of ECL, resulting in non-payment of dues to the petitioner. Concerned authority of ECL is directed to forward claim of the petitioner, being the wife of this employee of ECL, who died on 20th March 2020, by 48 hours from date. So on receipt of those benefits, on receipt of such claim, respondent number 8 is directed to release provident fund and pension / family pension in favor of the petitioner by 7 days thereafter with interest. From the date from which husband of the petitioner was entitled to get those benefits, was entitled to receive those benefits till date of payment. Sentence number 4. With necessary interest. Concerned authority of ECL and Coal Mines and the regional commissioner Coal Mines Provident Fund organization, being respondent number 8, are directed to file a report in the form of affidavit disclosing the steps taken for making payment in terms of the direction in terms of the order passed today by 10 days thereafter. Stop. It is submitted on behalf of the petitioner that gratuity till date has not been paid. Stop. Learned advocates representing ECL and Provident and Coal Mines Provident Fund organizations have jointly submitted that gratuity needs to be paid by the controlling authority under the Payment of Gratuity Act, being respondent number 9. Today, respondent number 9 is not represented. Stop. Learned advocate representing the petitioner is directed to serve notice enclosing copy of this order upon the respondent number 9 or the learned advocate representing respondent number 9 by 7 days from date and file further affidavit of service on the next date.
And I direct serve to the
Stop.
controlling.
This is the matter under the same heading for further consideration on 48 hours down. 48 hours, 10 days. On 22nd December 2020. Right to serve upon the learned advocate who represents Provident Fund organization. Because it will help you. If somebody appears on the next date, then a direction can be issued. Otherwise, again, there will be a complication relating to service. Yes.
In the case of LCS amount, that has not been paid. LCS life cover
Next
scheme.
matter.
Item number 5.
I am for the petitioner. Lordship,
am
this
the
matter,
respondent number 227.
Lordship, the matter is related to the CMPF account and the pension. The petitioner retired superintendent in the year 2001. He has received
Retired
2001.
date.
Date is not clear.
On which date petitioner retired?
That is not clear, Lordship.
Why not?
The document related to that is not
You're
available to me
representing
right
the
now.
petitioner, you do not know when petitioner
No,
retired.
Lordship, that the retired date of retirement is 2001, but that
Which
document
date?
is
1st
not.
of January 2001 and 31st of December
Yes,
2001.
Lordship, that is actually the document available to me. That is not clear from that document.
You are the employee, you do not know when you retired.
Lordship.
Whether the wife has come or the employee has come.
No, no, employee.
So he doesn't know when he has retired.
It's unable to disclose this.
Yes, you are
exact
representing
date.
Coal India.
I am for the respondent number 2 to 7, ECL authorities.
When petitioner retired.
I did not get the full instruction, my lord. I am praying to file a report because
Thing is required when petitioner
my lord, in this case, problem is there
Yes.
regarding the identity of the persons. His father's name recorded differently, and actually disbursing
That's why
authority.
you do not know your date of retirement.
Lordship, the police
Nobody
verification
will
come.
believe it. After serving for a long period of time,
No,
he has
Lordship,
forgotten his date of retirement.
Lordship, kindly come to
It
page.
does not instill confidence in the mind of the court.
And
Lordship, the
regarding-
police verification, kindly consider the police
Regarding
No simple thing, madam, when you have retired.
the date of retirement, that is the document related to the date of requirement is not available to me, but in the year 2001, from there,
The big submission, when you have
convention.
retired, tell me.
Date of retirement.
I am trying.
Petitioner has come up with the present writ petition in comma, inter alia, comma, praying for
The Lord
release
will
of
see page 22 of
retirement
the
due.
petition, my lord.
Being the since petitioner rendered service in Coal India Limited. In Coal India.
Not Coal India.
In Eastern,
2 to 7 is ECL authorities. ECL authorities.
in Eastern rendered service under Eastern Coalfields Limited within bracket ECL. Next paragraph. However, on query being posed to the learned advocate, it is not apprised that when petitioner has retired. Stop. Learned advocate for the petitioner as well as learned advocates for the petitioner and ECL authorities are directed to obtain instructions. Here, stop. Hearing of this matter stands adjourned. Release the matter under the same heading for further consideration on 15th December 2025.
15 December I shall be outstation. It will be 15, 16, 17. 3 days I will be outstation. It will be 18th of
11 December 2025.
11 December.
Next matter.
And Lord, there is some disputes in name.
Let them come up with
Disputes in name.
Chinad
Yes.
Gowda and Chinad Patsu.
Yes.
Next.
Item number 6.
That is the main problem. For name is different.
You also take instruction. I have directed you. Yes.
Malos, this is a matter for Malos retirement benefits as well as Malord for compassionate appointment. The petitioners are Malord. The yes. 6.
Yes.
Yes, Malord. This is for Malord. And the Malord the
Who is
petition.
appearing for the respondents?
Because I have served Malord.
But
The affidavit of service is complete.
What you are paying for?
Malord's retirement benefits as well as Malord's compassionate appointment.
Court fee.
Malord's
Fee in respect of one petitioner was put in. There are 4 petitioners.
then Malord's deficit course fee has to be paid.
What about service upon Eastern Coalfields?
Yes, Malord's that is complete.
So, you have served.
Yes, Malord. I have given the Malord's affidavit of service.
খুঁজে বার করুন।
Malord's page 7 and page 5.
না আসেনি পরে আসো এই কোথায়
Because the only thing is that, my lord, respondent number 5, National Commission for Scheduled Caste, has not been, my lord, served. That is, my lord, our fault.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Learned advocate representing the petitioners have prayed for leave to put in deficit court fees. So, learned advocate for the petitioner shall be at leave to file deficit to put in deficit court fees by 7 days from date. Next paragraph. Petitioner, learned advocate for the petitioner shall also be at leave to serve notice upon respondent numbers
5 minutes.
I am appearing for list number 4.
4.
I am appearing 4.
Respondent number 1 to 3. Learned advocate for appearing for the petitioner shall also be at leave to serve notice enclosing copy of this order upon non-appearing respondents or the learned advocates representing those respondents by 10 days from date and file by 10 days from date. Stop. List the matter under the same heading for further consideration on 18th December 2024.
Grateful, my lord.
Serve notice upon the learned advocate if it is possible.
Yes.
Item number 7.
7, Lordship, I'm praying for a very short pass.
Why?
My lord, my senior engaged in court number 8. Kindly, my lord.
Union of India, who is appearing for Union of India?
Mr. Singh is appearing, your lordship.
Yes.
Mr. Singh is appearing in this matter, lordship.
The same.
Mr. Singh, I am also praying for a short passover. He's on his legs.
Item number 8.
I am in the reason decision. Reason decision. The second round of litigation led that 2 prayer was made led. One is led declaration of my service, and other is led
Where you are serving?
And I appear for WBSCDCL and my junior is
state
there.
will not come to the reason decision. Page 37 led. Relevant parties at page 37. Starts at page 37. Relevant parties at 40.
চিনি তো দাদা
Now attached to me. I mean, only এখন এই বিজ্ঞানের practice করে এবার হয়ে গেছে and very hard working also, very hard working. এখানে থাকা মানে ঠিক কমপ্লিট হয়
You have put in deficit court fees.
এইটা সেটা হাজার ও ট্রান্সফারেবল তো भी हाँ
Last page is the acknowledgement.
27 petitioners are there.
Last page is the acknowledgement.
কত হয়েছে আমাদের
পরেরটা দিয়েছি পরেরটা দিয়েছি
চলো তো কি সবার শেষে সবার শেষে Why? পিয়ুষ স্যারের সাথে যে নিয়েছিলাম না পিয়ুষ সাথে
What interim order you are asking for?
Blood, this point, since I'm not working against any sanction post, I'm not entitled to get benefit of this notification. This has been settled by the division bench of our High Court, and they went up to the Supreme Court. Supreme Court has affirmed it. This is the judgment. Yeah. Two paragraphs I'll show that. This particular clause has been interpreted by the division bench. This is 2024 LAVIC 4234. In fact, I was hearing on behalf of paragraph 4. Submission made by the Land Council representing the state. The respondents were not engaged against
Paragraph 4.
paragraph 4. Yes, ma'am. Submitted that the writ petition private respondents were not engaged against any sanction post. They had been engaged on daily wage rated basis. Public Health Engineering Department or the Directorate does not have any involvement in any manner in the process of their engagement by the respective Gram Panchayat. Now,
what you are seeking, enhancement of remuneration.
Interim prayer I have made.
As it is contemplated under 2024 order.
Yes.
Or just a minute.
Put it. It's a bench.
1st of March 2024, this 15,000 and 17,000.
Yes.
You are seeking enhancement or regularization?
At the interim prayer, my prayer is enhancement. My final prayer is regularization. Now, interim prayer has been decided by the division bench. Paragraph 19
many things. Acceptable or not, that is different. That is different. We must have the chance. You have the chance. World 244 for station.
Where this
paragraph 19
were working in or the respondents were working so far this Ranjit Saha is concerned, case is concerned, where they were working.
They were employed with the Panchayat, though they were selected by them that department.
Which department?
That PHE department.
But whether this memorandum dated 1st of March 2024 has any application in case of statutory?
But I have annexed. But it is applicable for all. Here, we are working with a government company.
First, since you are relying upon this
paragraph 19 statement. The issue, may I read? The issue whether such repetition stands excluded by this.
Report of the National Police Commission. Paragraph 19.
Paragraph 19 starts with the issue is whether. At page 5. At the bottom at page 5. Yes. The issue is whether such repetition stands excluded by reasons of clause 10, the memorandum dated September 16, 2011 or not. Such clause has provided that the memorandum dated September 16, 2011 will not apply where the contractual engagement has been made without any sanction post and for specific project for a very temporary period up to maximum 6 years or on conclusion of the project, whichever was earlier. Then the exclusion was the memorandum dated September 16, 2011, namely clause 10 has to be constituted strictly against the state as the state is author thereof. Moreover, the state has extended benefit of casual delegated contractual workers by such memorandum. Therefore, such clause has to be interpreted so as to extend the benefits to such targeted beneficiaries. Reading clause 10 of the memorandum dated August 16, 2011 on the anvil of the propositions noted in the preceding paragraphs, it provides that the benefit of the memorandum will not be available when the following conditions are simultaneously satisfied. 1. Contractual employment had been made without any sanction post. 2. Contractual employment had been for a specific project. And third is contractual employment had been made for maximum period of 6 years or till the conclusion of the project, which was earlier. In our understanding, all three conditions as noted above have to be satisfied for a contractual employee to be denied the benefit of the memorandum dated 16, 2011 by reasons of clause 10 thereof. The facts and circumstances present here, if you look to the recent decision, yes, admittedly we are working beyond 6 years.
2007 onwards. Prior to that.
Now they are referring.
Cop you are working and thereafter.
Yes.
It was taken over by
the WBCDCL.
Thereafter you are working from 2017 till date.
Yes, ma'am. Now they are referring this.
But it has been stated in the order that you are working. You were working in Singur Horipal Rural Electric.
That was taken over by WBCDCL.
Not as a permanent employee.
No, contractual.
Yes.
Contractual. That's why I'm saying.
One of the condition is this, as delineated in paragraph 21 of this judgment of Ranjit Saha, that contractual engagement had been made without any sanction post.
Yes. Clause 10 of 2011 the mother notification refers to this clause, and which says that if your service is up to 6 years or until the project is continued, then you cannot get benefit of this circular. Here, we are working beyond 6 years and we are discharging perennial duties of my employer. Therefore, so far this clause, reference of this clause 10 to deny my benefit of 2024 notification cannot sustain. That's why I have made this interim prayer.
No, if it is not engagement against a sanction post, then how your case can be substantiated?
So far, final relief is concerned.
No, regarding the enhancement of remuneration.
Because the requirement of clause 10 is division based and interpreted in this way that not only unsanctioned post, you have to satisfy two more conditions, that you are not serving more than 6 years, that your project is for limited period. If these three conditions is satisfied simultaneously, only then you can deny this benefit. In any event, the delegated worker or the contractuals Mostly my lord does not work my lord, in sanction post.
Now, where is this
Circular.
memorandum dated 1st of March 2024, which was issued subsequent to the
Yes, ma'am.
this the parent memorandum dated
But parent
5th
memorandum,
of September 2011.
yes, ma'am.
My lord, the
At
2024
page,
memo is at page 76 and
Because it
2011
originates
memo.
from 6th of September 2011.
80, my lord,
80 of your writ petition.
of my writ petition.
Yes.
No, my lord, in order to provide security of tenure, appropriate emoluments and certain terminal benefits subject to fulfillment of certain conditions to the casual delegated contractual workers who have remained engaged in various government establishments for a considerable period of more than 10 years in connection with implementation of various scheme projects of the various department of the government. Two memorandums also were issued.
But it talks about government establishment.
Yes, ma'am. Then, my lord, the question of making the provisions of two aforesaid orders more effective and suitable to the convenience of the government establishment and organization, all are included now, has been under active consideration of the government for some time past. Now, my lord, it is not confined to the department. After careful consideration of the matters and in supersession of the aforesaid orders and all other orders issued by other departments in the matter, the undersigned is directed by order of the governor to say that the governor has now been pleased to order that the casual delegated contractual workers who are remaining attached to various establishments of the government department, directorate, regional office, other organizations for not less than 10 years. Now, all are included.
Various establishments of the government departments, directorate, regional offices, and other organizations.
And then in fact, my employer does not dispute this, that whether it is applicable or not. They say only that I am not working in sanction post. I'm not stateway, Milad.
Just a minute. Yes.
Now, Milad, therefore, the condition is that you have to work at least for 10 years.
240 days in a year.
In a year. That is the condition, Milad. And Milad, clause 10 is at page Milad 81, bottom. This is the Milad exclusion clause, Milad. The provision of this order will not be applicable where contractual
Clause 10.
Clause 10 at the bottom, just.
These are to be read along with this subsequent notification or memorandum.
All are revision.
1st of March 2024,
Yes.
and which
All
has
are
been interpreted by the division bench in paragraph 21, that all the three conditions are required to be fulfilled
Together.
in order to deny such benefit.
Together.
Now, your contention is this: yes, it was. If this court proceeds on the premise that these appointments were not against the sanction post, even then, if the working period is more than 10 years, in that event, they are entitled to it.
Now, my lord, recently, my lord, 2024 and 2025, two more judgment has been passed by the Honorable Supreme Court, my lord. But my lord, the court has directed the employer, even if they are working as a casual employee, my lord, to be to regularize them, to stop exploitation, my lord. One is my lord,
Mr. Mujumdar, you are not audible.
Sir, Janet.
You are not
Yes,
audible.
my lord. Am I audible, my lord?
Yes.
My lord, Mr. Ahmed submitted that there is a judgment rendered by the Honorable Division Bench of this Honorable Court
Yes.
interpreting the relevant memo, that is memo of 2011. Now, my lord, my submission would be that at this stage, my lord, the interim order, my lord, first of all, my lord, we have to go through that judgment. Secondly, my lord, this judgment was not placed before the authority when this recent decision was taken.
Yes.
Secondly, my lord, most importantly, kindly take the prayer B.
B.
B for Bombay, my lord.
For
B.
just a minute.
Main prayer লিখে দিয়েছে।
The Lordship kindly takes prayer B. That's the main relief sought for. One of the main reliefs sought for, along with prayer H.
By revising and restructuring the remuneration.
Yes, my lord. Then, my lord, the interim order, which is prayed for, my lord, is in the nature of main relief. So, my lord, we should be given an opportunity to file an affidavit, very short affidavit. Your Lordship may can fix the time. Give us 2 weeks, 3 weeks, whatever may deem fit to your Lordship.
No, no,
And
there are two parts to there, Mr. Mujumdar. There are two parts.
yes.
One is regularization.
Yes.
Another
Right.
is enhancement of remuneration in terms
Correct.
of this memorandum dated 2011, 16 September 2011, read with 1st of March 2024.
Correct, my lord. Absolutely right.
Now,
Absolutely.
Mr. Ahmed has submitted, there is some substance in that submission that regarding the prayer for regularization that can be heard out on exchange of evidence.
Right.
But for the remuneration is concerned, since the issue is decided by the Honorable Division Bench in the judgment of Ranjit Shaha,
Yes.
why the remuneration will not be enhanced?
My answer would be very simple. Kindly take the order, the impugned order. Kindly take page 40 of the impugned order. If the interim relief is granted today, practically the impugned order would be set aside today itself. Kindly take the impugned order.
But where is the discussion with regard to entitlement of the petitioners to get remuneration in terms of this?
Yes, my lord. Kindly take, my
notification?
lord, that is what I'm on. Kindly take order at page 40, the second paragraph. My lord, kindly take, my lord, may I just read out that portion of the
Yes,
order?
yes.
In the representation dated so and so, it has been demanded to implement the provisions of memorandum dated 1st of March 2024 of Government of West Bengal. As per the said memorandum, minimum monthly remuneration for Group D employees is 15,000 and Group C is 17,000.
17,000.
Along with higher pay for those who have completed 5, 10, 15 or 20 years of continuous service with the annual increment. This is stated here that the memorandum being number so and so, dated 1st of March 2024, originates from the memorandum number 9008 so and so, dated 16 September 2011 of the Government of West Bengal Finance Department memo, where under clause 10 it has been categorically mentioned that the provisions of this order will not be applicable where contractual engagement has been made without any sanction post. The deliberated and casual workers previously engaged under the Singur Haripal Rural Electric Cooperative Society was never posted there. Against any sanction post, the status of engagement of those casual and deliberated workers there was purely contractual to run the business of the said cooperative. In terms of the office order dated February 28, 2008, W West Bengal Electricity Regulatory Commission, followed by resolution of Board of Directors so and so, this cooperative has been taken over by WB SEDCL along with its assets and liabilities with effect from 29 February 2008. Along consequently, the status of terms and conditions of engagements of those casual and related workers of the said cooperative continued to remain the same when its business was taken over by WB SEDCL after revocation of license of Shrell Corp. Hence, provisions of memorandum being number so and so, that is 1st of March, is not applicable to such contractual and delegated workers, and there is no scope for to regularize the appointment under WBSEDCL. So two issues were decided by the authority. One, the commensurate pay scale in terms of the
based on only one fact that their appointments are not against
yes.
sanction.
I
Now,
cannot travel.
if we fall back on paragraph 19 of the division bench
this judgment,
Ranjit Saha, where it has been clarified that all the three conditions, that contractual engagement had been made without any sanction post, then contractual employment had been made for a maximum period of 6 years or till the conclusion of the project, whichever is earlier, and contractual employment had been made for a specific project. If all these three conditions are fulfilled, in that event, petitioners can be denied the benefit
I understand, my lord.
It is and 2024 notification.
Yes, it is the satisfaction of the cumulative effect of the restrictions.
Right.
It is the satisfaction of the cumulative effect of restrictions.
Not on a one-point agenda that whether the appointment was made against the sanction post.
Right. Absolutely, my lord. Grateful to your lordship. May I just point out one thing, my lord? In my understanding, my humble understanding, my lord, in fact, my lord, neither this 2011 memo not the 2024 memo is applicable to the corporation at all. Why I tell you, lordship, my lord, kindly take the memorandum of 2011. Subject to correction by Mr. Ahmed. Well, I will stand corrected. And I will take the advantage since I am appearing online. I can always take that advantage that I will stand corrected.
Yes.
So, well, kindly take, first of all,
page 80.
I'm sorry, page 80 it starts.
Third paragraph, Mr.
Yes,
Majumdar.
first paragraph, absolutely correct. Third paragraph.
Yes.
To government departments, directorates, regional offices, and other organizations for not less than 10 years continuously as on 1/8/2011.
And other organizations?
Yes, my lord. That is the qualification your lordship will find at Roman 12 of this memorandum at page 82. Which are the other organizations? The benefit of this memo will be applicable mutatis mutandis to what? Panchayat bodies. Ranjit Shah was a case of Panchayat body. ULBs, that means the urban local bodies, and statutory bodies. WBSEDCL is not a statutory body, it is a government company. So, the other organization expression has to be read in the light of Roman 12 of the memorandum under consideration. That is my humble understanding. That is my humble submission before your lordship.
Panchayat bodies and urban local bodies.
That is my lord, Panchayat and the municipalities and statutory
bodies.
But this is not a statutory body. This is a corporation under the Companies Act. But a classical case of, my lord, say for example, my lord, WBSEB, my lord, those Deshbandhu Ghosh, all those old judgments of 1985, 86, Central Inland Water, it may be a state. It is a state under 12, but it is not a statutory body. It's not a statutory corporation. So, my lord, I need to put these facts on record. My lord, kindly allow me to file an affidavit. Kindly grant me a short time. My lord, your lordship will find the two-pronged prayer. Both the prayers are being reliefs claimed for. So, my lord,
what are the differences between company and government company and statutory bodies?
My lord, your lordship will find the difference. My lord, your lordship has gone through these judgments a number of times. I not remind your lordship, my lord, kindly take the case of, my lord, any corporation like Central Inland Water Corporation, Brojonath Ganguly's case. Right? Article 12 company. One matter, my lord, which we did, my lord, my brother, in fact, was the main architect of that matter, the Bamal matter. That was again a government company, Partho Sharathi Shenroy versus Bamal, which is reported now in SCC. These are government companies, statutory bodies stand on a different footing. And the lordship will find the first of this kind was this, my lord, the case of Rajasthan State Electricity Board versus Mohan Lal. This is a 67 or 69 Supreme Court judgment, which was considered in, my lord's this 1975 Supreme Court 1329 and also 1975 Supreme Court 1331. My lord, one was the case of LIC, all my lord, LIC, etc. Those are statutory corporation. Your lordship will recollect GIC, LIC, etc., etc. The other was the case of, my lord, a body which was not statutory in nature. And the judgment was revisited by the Honorable Supreme Court in Pradeep Kumar Vishwas versus IICB. That is 2002 5 SCC 111, if I am not wrong.
Now, but this aspect was not gone into by the authority.
But this aspect was not gone into.
It was not addressed in the impugned order.
That was not addressed
This
in
is
the
not
impugned order.
applicable in case of WBSC DCL.
But kindly take the representation for once. The representation which my learned friend's client
The
made.
only reason on which this the prayer of the petitioner was refused was that their appointments were not against the sanction.
Absolutely, my lord. There is no doubt about it. But my lord, your lordship will be examining. I understand the next submission which Mr. Ahmed would make and what is passing through your lordship's mind, that can the affidavit improve the order? Right, my lord, subject to your lordship's kind consideration. We fall back on my lord MS Gill, Mahendra Singh Gill's case that orders do not become better with the passage of time. Question is that there is an exception. My lord, when there is an exception, when the issue is a matter of general public importance. This issue will determine how these non-statutory bodies, though they are state within the meaning of Article 12, would have to treat the delegated or casual workers in their roles. So, my lord, kindly allow me, give me 2 weeks time. They have been waiting for 13, 14 years, 15, 16 years. My empathy is with them. It's not that my empathy is not with them, but my lord, I have to do justice to my client. My empathy is with them. It's not that my empathy is not with them.
Every day I learn from him.
Having used this judgment of the Honorable Division Bench, I have asked you that the respondents in that Ranjit Shah matter, he was the employee of a Panchayat department. He was deputed in Panchayat department from the government establishment. Here it is WBCDCL. The question is also, it is also struck my mind that whether this circular or
will be applicable or not.
apply in case of WBCDCL or not.
One of them, my reply has already
was
put to him.
inclined to, having heard you, court was inclined to pass an order for enhancement of remuneration. But Mr. Potilka, in his usual eloquence, has submitted certain points which needs consideration by this court.
Understand?
There is a fine distinction in between the statutory bodies and government companies.
So may decide on affidavit, but only one reply I want to give, subject to lordship's consideration, that this memorandum, while superseding earlier two memorandum, which was confined to government and government departments, this was issued to extend benefit to all, under whom the state has control. Now, this last clause referred by Mr. Mazumdar,
Clause 12. Clause 12. Clause 12.
That has
of
to be
2011.
That has to be read along with paragraph 3. First.
But that is the issue that needs consideration at the final hearing stage.
That is in addition to what has stated in paragraph 3. Kindly read this is up to other organizations. Government having control over the organizations. Now paragraph 3.
Who is appearing for the state government? Mr. Rai Mukherjee.
I'm for the state.
You are appearing for?
Mr. Rai Mukherjee is with me, my lord.
I'm for the state.
State can clarify because they are the author of the document.
Do you have any instruction?
Lordship. I have to take instruction.
Let them file a short report. Otherwise, your lordship knows.
I know what will be the
But
stand.
I do not stand in the way of an expeditious hearing.
Affidavit, then the matter can be gone in.
Fixes it.
In all matters, you make prayer, the identical prayer, and embarrassing this court. That fixation of date for filing for hearing of this matter.
There are people who will be.
Affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph. Document in support of putting in deficit court fee is also filed and taken on record. Next paragraph, in the writ petition ordered in the writ petition ordered dated 15th October 2025, issued by the general manager within bracket HR and capital A close bracket hyphen planning WBSCDCL is questioned, whereby prayer of the petitioners for enhancement of remuneration and regularization of service in WBSCDCL have been spurned. Stop. Next paragraph. Petitioners have made a prayer that issue relating to regularization of service of the petitioners may be dealt with after calling for affidavits. But in terms of memorandum being number 1091-F within bracket P2 subcapital close bracket dated 1st March 2024 read with read with previous government memorandum number 9008-capital T within brackets capital P close bracket Kolkata, comma dated 16th February 2011. Petitioners plural apostrophe remuneration needs to be enhanced as contemplated under the aforesaid memoranda. Under the aforesaid memoranda. Stop. In support of same, reliance is also placed on the judgment of the Honorable Division Bench passed on judgment of the Honorable Division Bench reported in 2024 Lab IC 4234 within bracket State of West Bengal versus Runjit Saha and others. Stop. It is submitted based on observations made in paragraphs 9 Runjit Saha Supra. All the three conditions as delineated in memorandum dated 16 September 2011 need to be complied, need to be fulfilled in order to deny the benefit of enhancement of remuneration. Next paragraph. However, Mr. Obrotos Mojumdar, learned senior advocate representing WBSCDCL on virtual mode, has opposed this writ petition, has opposed the prayer for interim order, thereby directing the concerned authority of WBSCDCL to enhance the remuneration on the score that memorandum dated 16 September 2011 is not applicable in case of WBSCDCL, which is a government company, not a statutory body. And in this regard, reliance is placed on clause within bracket small Roman 12 of the said memorandum dated 16 September 2011. Next paragraph. Having considered the respective submissions made on behalf of the parties, stop. Next paragraph. Though court was contemplating to pass an interim order relating to enhancement of remuneration, but taking note of the submissions made on behalf of WBSCDCL that memorandum dated 16 September 2011 is not applicable in case of WBSCDCL being government company. It is found that the issue needs to be decided on exchange of affidavit, whether petitioners are entitled to get the benefit of regularization as well as enhancement of remuneration in terms of government memorandum dated dated 16 September 2011 and subsequent and subsequent to Corona, and 1st March 2024. Stop. Stop. It further appears that the case of Ranjit Shah Supra was confined to to an employee or to a person who was working in PWD, but subsequently worked in PHE, Public Health Engineering, in Public Health Engineering Department, but subsequently worked under Panchayat authorities. Stop. But in the present case, petitioners are working working under WBSEDCL, and it needs to be considered whether WBSEDCL ought to be considered an organization where memorandum dated memoranda dated 16 September 2011 and 1st March 2024 are applicable or not. Stop. Therefore, at this stage, court refuses to pass the interim order. Stop. Let affidavit in opposition to this writ petition be filed by 3 weeks by 3 weeks from date. Stop. Affidavit in reply thereto if any be filed by 1 week after ensuing Christmas vacation. Petitioner shall be at liberty to mention the matter before the after the time fixed herein above for extending.
Grateful, my lord, grateful. I take your lordship's kind leave, my lord.
PHE department.
I take your lordship's kind leave, my lord. I'm so grateful.
They have, and it has been enhanced. Fisheries Development Corporation. This is a different case.
Grateful, my lord, grateful.
Please call the list.
Item number 9.
I'm for the union admin respondent 1. Last start.
Yes.
Your lordship last time asked us to submit that whether any reason was given to him. It was explained to him. Kindly see, he was telling that he has not yet driven the vehicles. Yes, this is a kindly see the this is a route from one entry point to the last line, straight line. I have got a video also. He drove the car, but without the seat belt. And as per 194, section 194 of the Motor Vehicles Act, this is a compulsory nowadays. And it was rejected by the motor vehicle, not by the CISA.
But where it is stated in this order dated 25?
Now, just sitting, I have explained. He has explained. Kindly see the.
Who has explained where?
Did you say to him? That's why he signed. After hearing, kindly his annexure, page 25. I have been told about the grounds of my rejection.
Where? Page 25.
Page 25. Kindly see.
Yes, page 25.
Below that, he has put his signature. And there is an appeal to reconduct the test. Not only that, I can show you the video about his seat. He has not wear the seat belt. And he has driven the car from this point to that point. Thereafter, he used to drive the car to the
from point A to point B.
And no, just straight line only. One, not AB name. The second point, H track, reverse and negotiation of H track. Second photograph.
This is this photograph.
And second one. This is
next second
H
table.
Track.
H track.
He started from the enter 1.
He started from enter
1.
Yes.
And he drove the car up to the arrow marks, straight line.
Yes.
Thereafter
came back towards the same.
No. Thereafter he used to
exit
travel
point
from
5.
He used to come back to 5.
So 1 to 5.
1 to 5. But he was not allowed because up to the straight line is a back gear. It is not a front gear. It is a back gear. And the photograph can be shown that he was not wearing the seat belt. This is a video I am having.
First he drove straight.
Then only the motor vehicles officer was that recruitment interview was taking. He stopped him. You stopped him. It's like, I can show this. A video is here with me. I can show that.
When he drove the car with the help of back gear.
Yeah, that was the instruction. That is the instruction.
From which point to what?
Reverse and negotiation H track. H track just below the H track. That is this is a test is this, and from 4 to 5 it will be front gear, straight, back gear and then straight. This is the test, total test.
But entire stretch he drove without any.
No. Yes, first line. He this is a video is there. He without the seat belt, so he was allowed to drive up to that point. Then he stopped.
Very well, put it on affidavit. Put it this on affidavit.
Much
No, I have missed one thing. That at the bottom of page 25, it is stated that I have been told about the grounds of my rejection.
Yes.
Court was proceeding on the premise that no reason was assigned. But that is not the fact. You put your signature and where it is stated that I have been told about the grounds of my rejection. In terms of the order dated 25th November 2025. Matter is heard today when learned advocate representing Union of India has submitted some documents in order to demonstrate before this court that petitioner was given permission to drive the car, but he drove the car without any seat belt. Stop. Attention of this court has also been drawn to relevant part of page 25 of the writ petition, wherefrom it appears petitioner certified that he was informed about the grounds for his rejection in the driving test. Next paragraph.
At the time of
Late affidavit in next paragraph. Learned advocate. Now, concerned respondent authority. Next paragraph. Concerned respondent authority is directed to file a short affidavit disclosing the reasons for declaring the petitioner not qualified in driving test. Stop. Let such affidavit be filed by 10 days from date. Stop.
10 days.
10 days. List the matter under the same heading. Very well. By fortnight from date. And list the matter under the same heading for further consideration on 17 December 2025.
Kindly protect me for
Sorry, I am not satisfied.
this is the notification your lordship will.
Next matter.
Can it be?
Sorry. Next matter. Please, next matter. Sorry.
Item number 10.
Yes. Sorry, please, next matter. Sorry.
This is the notification.
Yes, whatever may be the notification, I am not satisfied. You have put signature that you have certified that the reasons are told to you. Yes. Sorry. Sorry, please don't disturb the proceedings of the court. Sorry. Please, next matter.
This is the notification.
Yes. Next matter.
Item number 10.
Yes.
I shall be driving with officer to order dated 25th of November 2025, Lord. Will also be kindly go through the order. Lord, the progress fund has been paid.
Yes.
Or we have taken instruction, Lordship. The Provident Fund has been released on 27/8/2025.
27th of August 2025.
27th of August 2025. And he has also received it. And so far the provisional pension is concerned, which your Lordship also queried. It is under process. Lordship kindly gives us some more time. We will be processing it further.
So 27th August 2025 PA paid.
Yes.
Entire PA paid.
Yes.
And the provisional pension.
Provisional pension is under process. Lordship kindly gives us some more time so that we can process it further.
Lord, I leave it to Lordship, Lord, as my learned friends, it appears to be that his submission is very inadequate, that he needs some time to take some steps for providing the provisional pension. Your Lordship, I kindly give him some time, 2 weeks time.
No, I'll direct them to pay provisional pension within certain time, and I'll dispose of the writ petition, granting them leave to take steps in accordance with law relating to initiation of disciplinary proceedings, and conclude it within 6 months.
Yes, Lordship kindly do so.
Make it one thing. Because what I think.
Because the last charge sheet was issued on 20th August 2025. Second charge sheet, that is the second. Last charge sheet was 20th August in terms of the leave granted by the divisional authority.
Yes. Lord, on the last occasion, Lordship, kindly remember that your Lordship's query from me was that whether this second charge sheet is not tenable or in normal. Lord, I have gone through the several judgments of the Honorable Supreme Court as well as the latest Lord, is circular issued by the railway authorities. That is there, if your Lordship kindly please for a moment and handing up a copy to my management also. That is the December 2025 circular is there, that you cannot hold, you cannot hold the second charge sheet or you cannot issue the second charge sheet. If my understanding wants to give an affidavit, he is liberty to do that. In closing, there is not all the circulars. The Lordship may kindly see this circular. This is the latest circular. At the copy of the I'm giving you a copy. Because second charge sheet is a penalty, it's a double jeopardy.
And that is not, my lord. They have went before the revisional authority. Revisional authority passed.
You file your affidavit, short affidavit, you give. What is the problem in it? There is no problem. Everything will be discussed by the court, and the court will delve into the question, and it will create a precedent that yes, in case of the double jeopardy or the second charge sheet is issued, the judgment can be cited before the another matters. I am equipped with the Supreme Court judgments, but I do not want to place it because my friend wants to file any affidavit, he will do so.
দিন স্যার একটা কপি দিন, আপনি তো রিলাই করছেন।
93 যদি বলেন কি এটা কপিটা না, you cannot do that. I will sort affidavit, everything will be clear. Subsequent cases, this will also happen. The employees after retirement.
Problem is here net is very slow in court.
Nowadays, we have become very much techno-savvy. That's the problem. able to take it. We will grant of 10% of the taxable. We will need to pass the percentage. Continue.
In BC Chaturvedi's case, Supreme Court has decided that at the point of time, at the point where the proceedings was found to be erroneously proceeded with, in that event, court can direct that from that stage, a fresh proceeding is to be initiated.
But I'm not disputing that.
The celebrated judgment,
I have seen
1995 Supreme Court, 1995 6 SSS 749. So therefore, there is no ambiguity so far review is concerned, order of the review.
On the submitting to sum up everything without consuming the valuable time of your lordships. Your lordship has clearly observed that very well they will take some time to process the payment of the provisional pension. Very good. That is the first part. Second thing is my submission is that departmental proceedings may continue, but no final order will be passed without the leave of the court. That's all. Matter ends. In the meantime, you file your affidavits, placing all the facts. Otherwise, they may say that I have not been given an opportunity to file the affidavit. That is a very eloquent submission of mine. I'm not saying that you stay right now. That departmental proceeding, the second chance. But no final order will be passed without the leave of.
এই অঞ্জন আমি পাঠিয়েছি এর প্রিন্ট আউটটা বার করো।
Because these orders are normally passed. And then we will look into the several judgments of the Honorable Supreme Court also. I'm equipped with the judgments of the Honorable Supreme Court, where they have said that you cannot do that. You cannot harass a person twice. After retirement, let him live happily with his family.
আর ইয়েতে তোমার হোয়াটসঅ্যাপে পাঠিয়েছি। চলে গেছে সেক্রেটারি অন্য নেই তো ও যায়নি এখন। পেয়ে যাবে। Your review order is at page
Also kindly comes to
22.
page 112. There are two parts of the sir, আমি একটু বলিনি, আপনি তো বললেন। There are two parts in the said review order. In one part, page Lordship kindly comes to page 112. That is the operating portion, though the order starts from page 108. The revision order.
112.
112 is the operating portion. For some omissions,
Dated 1st of April 2025.
yes, my lord. Lordship kindly comes to the last paragraph,
Page 112. Just
page 112.
Yes.
Now, Lordship, this order contains three parts. By first part, the previous memorandum of charge sheet was dropped. By the second part, he was reinstated. And the third part gives me the liberty to issue fresh charge sheet. So regarding the first two parts, he doesn't challenge it. And
But because those two parts
those two are in favor.
Are in favor of
Now,
the petitioner.
pursuant to this order passed, my lord, I have issued the fresh charge sheet. Now, if he was, sir, to bolte din, sir, if he was actually aggrieved, he ought to have challenged the third part also in the said review orders, which he has not done. Now he cannot challenge this further, and he cannot take the plea that I cannot issue the memorandum fresh.
Subject to
There is an abject acceptance of this part from his side.
subject to correction by my learned friend because he's highly experienced I don't have that much of knowledge of the criminal law, etc. But whatever I have gathered, my lord, suppose, my lord, a prosecution witness is deposing in the witness box, and my lord, that he has deposed rightly or wrongly. If, my lord, the prosecution wants that there should be fresh deposition, then he should made an application for recalling the witness. I'm putting this question to myself. All these are in violation of RPF rules. None of the above has been included in the articles of charges and the statement of imputation allegations materials. If my learned friend can show a single rule from the RPF Rules Act and the rules that this power is vested within, then I am out of the court. My humble submission before your lordship is this: I am not standing in the way. Let the departmental proceedings continue, but no final order will be passed without the leave of the court. From my little experience of criminal law, etc., suppose a prosecution witness has deposed and acquittal has been done. On that, the appeal can be preferred, or division can be said that yes, deposition has not been correctly done, so he should be held guilty. I am putting this question to myself. Under what provision of law? You have done the preliminary inquiry, you have done the departmental proceedings, and now in the revisional application you say that these rules have not been followed. When a defendant wants to make a scholastic argument, let him file an affidavit in opposition. Your lordship can stay the departmental proceedings, or no order will be passed without the leave of the court. But you cannot withhold the provisional pension or the pension without the sanction. Where is the sanction? Where from you have got the sanction? And I do not want to break the chain of your lordship thought. Criminal case is also pending against 8 or 9 persons. Charge sheet has been submitted. Witnesses are same. Documents are same. Everything is same.
No, so provident fund has already been
Yes,
paid.
yes.
Now provisional pension, you are.
It is being processed, lordship, and subject to, as per law, it will be
When
paid.
you have retired?
I have retired on 31st of August 2025.
In August itself, Provident Fund has been released.
31st of August 2021. 2025. Now the charge sheet.
I retired in the morning, and in the evening
The charge sheet was issued on 20th of August 2025. Not in the morning, evening. Prior to that.
That Rose Ramcha is also there. Rose Ramcha is there, Milord.
Why you are saying in the morning, evening you retired, and in the morning charge sheet was issued? It was issued on 20th August 2025.
It happened so, Milord. They did not, sir, on 31st days. Certain procedures are there. They have not followed anything.
Don't make wrong submissions.
Yeah, that's it.
So if the charge sheet is issued prior to your retirement on 31st August 2025, so why the petition, where is the difficulty so far the disciplinary authority is concerned in completing the proceedings?
They have not done anything. What failed from your lordship, that your lordship made the.
Where is the legal bar?
No, there is no legal bar, but there are judgments. I shall place all the judgments at the moment, Lord, by submitting before lordship.
I am asking you, where is the legal bar, including judgments?
No, I have got the judgments. If my learned friend does not use any affidavit, then there is no problem. I can.
I have expressed my mind also last occasion
what
that
I-
if prior to 31st of August 2025 charge sheet has been issued, then where is the legal bar in concluding the disciplinary proceedings?
There is no legal bar.
But yes,
Yeah.
that after retirement for an indefinite period, proceedings cannot be kept pending.
That's
So
fair.
I will direct the authority to conclude the proceedings by 6 months from date.
I am following your lordship's of the.
Yes, sure.
And they received the charge sheet on 23rd. If your lordship kindly comes to page 122 bottom.
Arey Baba, that is not the problem. The problem is that yes, you complete the departmental proceedings with the time, but no order can be passed without the leave of the court. And you process the provisional pension. You cannot stop the provisional pension.
Matter is heard at length in presence of the learned advocates representing the parties. Next, advocates representing the parties. Next, Mr. Dey, learned advocate representing Eastern, Southeastern Railway.
No, it is Eastern Railway.
Eastern Railway on instruction submits that Provident Fund dues were cleared and payment was made to the petitioner on 20 when it was
27th August
on
2020.
27th August 2025, and steps are being taken for releasing provisional pension in favor of the petitioner. However, some more time is sought for to complete the formalities prior to settling provisional pension case in favor of the petitioner.
As per law.
In accordance
Strictly as per
in
law,
accordance
nothing
with
beyond
law. In accordance with law. Next paragraph, in the writ petition, it is contended on behalf of the petitioner that charge sheet dated 20th of August 2025 is issued just before his retirement on 31st August 2025 in terms of the order passed by the
Revision authority.
revisional authority on 1st April 2025. So it is further submitted that after issuance of charge sheet on 20 August 2025, proceeding is kept pending for an indefinite period. Stop. It is also it is also the contention of the petitioner that after superannuation of the petitioner on 31st August 2025, such proceedings may not be continued. Next paragraph. Another limb of submission which is advanced on behalf of the petitioner is non-payment of retirement dues due to pendency of disciplinary proceedings based on charge sheet dated 20th August 2025 at the time of his retirement on 31st August 2025. Next paragraph. Having considered the submissions made on behalf of the parties, it appears that pendency of disciplinary proceedings against the petitioner pursuant to charge sheet dated 20 August 2025 does not impinge upon right of the petitioner to get provisional pension and provident fund. Stop. It is submitted. It is submitted that provident fund dues have already been cleared, and steps are being taken for releasing provisional pension. Stop. Concerned authorities of Eastern Railway is directed to complete the formalities and release provisional pension in accordance with law by fortnight from date in favor of the petitioner. Next paragraph. It is further found. It is also found that in terms of the order passed by the revisional authority on 1st April 2025 or dated 1st April 2025, petitioner was reinstated in service and was paid emoluments in and salaries. Stop. However, in the said order dated 1st April 2025, leave was granted to the disciplinary authority to initiate disciplinary proceedings by issuing charge sheet afresh, incorporating relevant charges. Stop. Pursuant to such order dated 1st April 2025, charge sheet was issued on 20 August 2025. However, 20 August 2025, which is prior to retirement of the petitioner on 31st August 2025. Stop. Next paragraph. Nothing is brought. Nothing is shown nothing is shown on behalf of the petitioner in order to substantiate his case that in the event charge sheet is issued prior to superannuation of an employee of Eastern Railway, disciplinary authority is not empowered to conclude disciplinary proceeding. Stop. Stop. As the disciplinary authority has issued charge sheet on 20th August 2025 in terms of the leave granted by the revisional authority on 1st April 2025, granted by the revisional authority video order dated 1st April 2025, comma, disciplinary authority is directed to complete disciplinary proceedings by 6 months from date. Stop. It is made clear. Next paragraph. It is made clear that petitioner shall not pray for unnecessary adjournment before the inquiry officer in order to defer the inquiry proceedings. And in the event prayer is made for adjournment before the inquiry officer, same shall not be allowed unless it is unless on the ground shown unless it is shown before the inquiry officer that the reason for adjournment is justified and is justified. Stop. Next slide. With the aforesaid observations, writ petitions, direct observations and directions, writ petition is disposed of. Urgent xerox.
One more thing I would like to add. Lord, the gratuity has also not been paid. You are also kindly direct.
You are not entitled to gratuity at this stage.
Very well, my lord.
Proceeding is pending.
Not only one thing, my lord, your lordship has directed me to complete the provisional pension process within 2 weeks' time. If your lordship kindly gives it 4 weeks' time, lordship. Why? At least 3 weeks' time, lordship.
August 2025 retire.
Lordship, at least 3 weeks' time.
Or a very well, 3 weeks.
I'm grateful. It's a leniency shown because the procedural.
Next matter.
Item number 11.
My lord, in this
Great
matter,
to do, lordship.
Mr. Sarwar Jahan is appearing on behalf of the petitioner, but my lord, since yesterday night, he is suffering from cold and fever. He could not come today, my lord.
At the time of call for the petitioner, Mr. Jahan is appearing.
Yes, yes, my lord.
At the time of call, accommodation is paid for on behalf of the petitioners.
And we have for the respondents here, my lord.
On behalf of the petitioner, since the learned advocate is unwell. However, you are for the state.
And I am for the Union of India, my lord.
Union of India is represented by learned advocates. Stop. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 10th December 2020. Next.
Instead of 10, my lordship, can it be on 11, my lord?
11 December 2025.
Item number 12. I am for the response.
Yes, sir.
Revised to not to.
May I submit? Item number 12 to 19 except item number 40. Already Lordship has decided the interest on gratuity.
Durgapur Projects Limited.
Yes, yes. Lordship, I brought
Revised interest, revised
revised.
benefits.
Last two was the revised and the rest are, my lord, same.
Orders.
My lord, so far 18 and 19, so far revised is concerned, your lordship kindly consider. On last occasion, it's my fault.
Let other matters be
Other matter similar.
be disposed of and thereafter.
Similar.
12. Just a minute. When retired?
Yes, ma'am. Retired petitioner retired from service on 30th November 2023.
30 November 2023.
Yes, lordship. Page 11.
Correct prohibition order. Order correction.
আমি জিজ্ঞেস করেছি।
এসো এটাকে একটু চেঞ্জ করে দিই। On 30th November 2023.
Yes, lordship.
It is submitted by the learned advocate represent 30 ওই অবধি ঠিক আছে বুঝলে এই অবধি ঠিক আছে। It is submitted by the learned advocate representing the petitioner that gratuity and leave salary was not paid to the petitioner within reasonable time after his retirement, and same was paid belatedly. Stop. According to the petitioner, he is entitled to receive. According to the petitioner, he is entitled to receive interest on leave salary and gratuity. Stop. Learned advocate representing Durgapur Projects Limited is represented by learned advocate. Who has made submission to oppose this writ petition on the score that Durgapur Projects Limited is reeling under shortage of financial constraints, reeling under financial constraints, as a result whereof delay occurred in releasing gratuity and leave salary. Next paragraph. From the submissions made on behalf of the parties, it appears that there was delay in releasing gratuity and leave salary in favor of the petitioner. Stop. In view, next paragraph. In aforesaid facts and circumstances, concerned authority of Durgapur Projects Limited is directed to pay interest at the rate of 6% per annum.
A simple interest.
6% at the rate of 6% per annum on gratuity and leave salary from the date following the date of superannuation of the petitioner till the date of release of those benefits within a period of 6 months from the date of communication of this order, failing which concerned authority of Durgapur Projects Limited shall be liable to pay statutory interest of 10% on the aforesaid amount or on the aforesaid benefit for the relevant period. Stop. Writ petition stands disposed of.
Only one request, Milord. Sometimes, Milord, some employees were, Milord, staying the quarter without paying rent. Milord, while disbursing the interest, Durgapur Project Limited is at liberty to realize that amount. So far, Milord, the quarter rent and all this, nothing else. That is, Milord, that was there in the earlier order.
একটা লাইন তারপরে অ্যাড করে দাও, while releasing the interest, concerned authority of Durgapur Projects Limited shall be at liberty to recover any amount which is payable by the employee or which is payable by the petitioner in favor of Durgapur Projects.
I'm good.
তারপর disposed of, তারপরে since no affidavits are called for, the allegations contained in the writ petitions are deemed not to have been read. এইটাকে ধরে করবে। Yes, next matter.
14.
Item number 13.
13, my lord, only date of retirement 31st January 2025.
Retired on
31st January 2025.
31st January
2025.
2025. 31st January 2025 retirement, same order. Affidavit of service, file your affidavit of service.
Yes, lordship.
Lord, except 14 up to 19.
Say, let it be called on one after another.
Item number 14.
Yes, that will be called on later. Let the similar order be passed. Taku.
পর 14 পর থেকে
Pass over. Item number 14 pass over. Next.
Item number 15.
Yes.
Yes, lordship. Item number 15.
Date of retirement বলে দিচ্ছি
মানে same 31st January 2025.
Retired on
31st January 2025.
same order.
Item number 16.
31st March 2025.
March
2025.
Same order.
Item number 17.
Yes, lordship. 17.
Retired on
29. February 29. 2024.
28 February
29th February.
29 February
2024.
2024. Where you have stated?
In pleadings and paragraph.
In which paragraph? Paragraph 4.
Paragraph 4.
29 February 2024, same order.
My lord, next one is the
Item number 18.
Yes.
That is, my lord.
Well, I will not much trouble to beg to trouble your lordship. Only one submission. Your lordship had already passed an order on that day, my lord. Somehow it was kept. Whether, my lord, they are entitled interest or not, your lordship kindly consider only one my lord, rule. Rule 15, my lord. So far the revise as per ROPA. My lord, kindly see rule 15. Just, my lord, rule 15A only. Area of salary, pay such and such.
Revised pay.
My lord, in due course, ও ছিল তো চাকরিতে পুরীতে ফর্ম 1/1/2020
29 ফেব্রুয়ারি 2020 ঠিকই আছে।
That means when the petitioner is eligible to get the NER benefits in due course. Due course means after 10 years.
Interest. I'm paying interest. Well, benefit, I have no objection. Well, so far interest is concerned, your lordships kindly consider in due course. I am emphasizing, my lord.
In due course means what? When it is payable to the petitioner, you have to pay the revised benefits.
We have paid.
Now it is provided under clause 15.
We have paid.
1st of January 2016 to 31st of December 2019, no area. Only notional benefits. But after that, from 1st of November 2019, petitioner is entitled to
Yes,
get,
my lord.
or the employee is entitled to get.
We have no question of
So
entitlement.
it was paid belatedly, revised
My
benefits.
lord, so
Why
far,
the interest
what
he
is
did
in
not
due
get?
course, your lordships
In
kindly
due
consider.
course meanings, meaning without that within time, as provided in clause 15.
My lord, as I have submitted, financial consistency is there. And so far, the in due course, what your lordships kindly consider. It's my respectful submission, my lord. I am not saying, my lord, because their word is there in due course. And my lord, that an event when
That means accordingly it is to be paid.
we have paid.
Yes, but when?
Interest. My lord, they have, my lord, claim for interest. They are my employees. They should have considered also the organization is, my lord.
2020
When petitioner retired?
My lord, petitioner retired on February 29, 2020.
29 February
2020.
Previously, you have filed a writ petition.
Yes.
Writ petition number?
Writ petition number 560/2023. Page 12.
That part is over. That we have paid with interest also.
I am correcting my order. 2023, 560 of 2023.
Yes, Lord.
Well, come back at 2.
After 2 minutes. এই ওই রোপা
আসেনি আজকে। When retired 30th November 2023? No, 29th of February 2020.
29 February 2020.
20.
My lord, kindly consider 15A and B of ROPA.
You have taken this point.
Ma.
Again, why you are repeating? Due course.
No, not only due course, all other allowances and benefits which are not mentioned in clause A above shall be paid with effect from 1st April 20.
আগের গুলো কি নিয়ে গেছে? ঠিক আছে।
In this case, when the revised order was paid by which order?
Page, that is page 16.
Page
16, 16.
16. March 2025.
Paid on 26, 6 days, no, after 3 months.
So in this case, petitioner is not entitled to get interest on revised leave encashment.
That's my respectful submission.
1st of April 2020, it was
1st of April.
It was implemented and petitioner retired prior to that.
And Milord, that not only that, if your lordships kindly consider Rule 4, sub-rule Milord, Roman 5, the definition of employee.
এখানে একটা লাইন অ্যাড করুন এই জায়গাটায় প্যারাগ্রাফ 6 এর in addition thereto in addition thereto on behalf of respondents reliance is also placed on rule 15 of the ROPA rules of 2020 বসে পড়ো এই যে এখানে অ্যাড এটা দেখে করবে So in my previous order, I have directed the benefits pay interest from 31st of October 2020. Disposed of. এটা দেখে করে নিন কারেকশনস গুলো করা আছে এখানে থাক পরে এর একটা সেম আছে
I have another copy of
yes
Item number 19.
10.
রোপাটা ওর মধ্যে আছে না
31st of March 2020 রিটায়ার্ড তো ওটার কপিটা দাও যেটা দিল দেখে দিচ্ছ কেন অ্যানাদার কপি একটা দিয়েছে ও এটা তো কারেক্টেড কপিটা ছেড়ে দাও Previous writ petition is at page 14, 557 of 2023. Where is the order by which revised benefits were paid?
1/8.
24th March 2025. প্যারাগ্রাফ 6 এ যেটা অ্যাড করলাম সেটা এখানেও অ্যাড হবে। হ্যাঁ, আমি এখানে ইন্ডিকেশনটা করে দিলাম। আগের অর্ডারটা একটু দেখি, দুটো জায়গায় একটু কারেকশন। এটাই কারেক্ট করে দিলাম তো? নে না, ওটা দিয়ে দাও। Yes, disposed.
But great.
Next occasion when we will come with the necessary corrections of the order which I have passed in order to cut short the matter. Yes.
That's why I'm telling my lord, to give the order, corrected order. He says no, my lord will not allow.
Pass over matter, item number 14.
Item number 14, I have got. Was appear on behalf of District Court.
Yes.
But today, what is it?
No order was passed previously. This is the first time.
No.
Who is the appropriate, who is the answering respondent?
Advocates were appear last occasion. Was he directed here?
ECL. Your service is complete. So then inform them not today.
Two advocates were appear.
What can be done today? Nobody is appearing. Inform them. Come back not today. Not today. Inform them that not today, tomorrow it will be taken up. Yes.
My lord, I am praying for no.
Wait, let the matter be called on.
Item number 20.
Praying for not today. I am for the petitioner led by Mr. Peter coming.
Your Lordship, Mr. Tapan Mukherjee is appearing for this.
We listed on 2nd December. Yes.
I am praying for not today.
Why?
My senior is engaged before the apex court.
Before?
Apex court.
Apex court. Then why it is stated, why it is scheduled to be listed today as per the presentation form? Before this court, in terms of the presentation form, matter comes. Then why it is, if he is to appear before the apex court, then why it is stated in the presentation form that matter is to be listed on 2nd December? Matter could have been listed as per presentation form on 5th December or any other subsequent date. Issue. You are appearing for the state. At the time of call, accommodation is paid for on behalf of the petitioners on the ground of the learned advocate. However, state respondents are represented by Mr. Tapan Kumar Mukherjee, learned additional government tutor. Next paragraph. Acceding to the request made on behalf of the petitioners, hearing of this matter stands adjourned. List the matter under the same heading for further consideration on 22nd December 2025. Next.
22nd December.
Next.
Item number 21.
To the Union of India. For the rest number 1 and 7. Under secretary.
At the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. However, you are Union of India. Union of India is represented by learned advocate. Writ petition stands dismissed for default. Parties to act on the server code.
Item number 22. I am for the petition. Petitioners before your lordships. Lordship is my lord, are the my lord, ex-servicemen who are below the rank of Havildar or below in the army and equivalent. Now, my lord, a recruitment process was initiated because in army, ex-servicemen, they have, my lord, a signing board where the unemployed persons will.
Court fee.
Court fees there also. Deposit there. I'll give the deposit code fees. Now, my lord,
Tell ID, I don't allow this. You have to put in court fee first.
Today itself will.
Issue.
My lord, kindly takes up the matter, my lord.
No, sorry.
Undertaking?
No, certainly not.
Undertaking, my lord. I will not.
Leave is granted to the learned advocate representing the petitioners to put in deficit court fees by 7 days from date.
Only instructions.
Since there are 39 writ petitioners, and at the time of instituting the writ petition, court fee in respect of one petitioner was deposited. Next paragraph, you are for the
respondent banks one.
Which bank? State Bank of India.
State Bank of India.
Next one, State Bank of India is represented by learned advocate. Next paragraph, list the matter under the same heading for further consideration on. December 2025.
My lord, in connection with that matter, my lord, a writ petition has been filed by my clients, my lord. In that writ petition, my lord.
In this matter?
The same, the petition.
Let the matter come up.
Let the matter
Yes,
come up.
yes.
Whether this matter will.
Next matter, please. Next matter, please. Renew your prayer on the next date.
Well, can it be before 10th? Well, any 4, 5, 6? Well,
no, sorry.
Well, I will not be here though. 4, 5, any date, my lord.
No, 4, 5 is not possible. I have granted them 7 days time. Other matters are fixed, not matter to be taken up according to your convenience.
I am not saying.
Yes. When you will come back?
Well, Christmas vacation. When you have somebody all over.
Yes. When you are leaving Kolkata? When you are leaving Kolkata?
After that, my lord, 13, 14, my lord. But 13, 14, but what I am saying, my lord, if it is possible before 8, then fine, my lord. If not possible, then well, I will just tell somebody to come.
In this week, it's not possible.
December, man.
Yes, yes. This week it's not possible. Then let it be on 10th. কবে বললাম 10th বললাম তো 10 তারিখ
If I'm here, my lord, I will definitely come. With 13, 14 going.
Yes.
If it's not, my lord, I will pray for accommodation.
Yes, yes. No, don't pray for accommodation. They may have urgency in the matter. So make an alternative arrangement.
Item number 23.
The 23, I appear for the state.
That I beg to appear for the petitioner. My lord,
Yes.
all the respondent, my lord, has not yet been, my lord, delivered because, my lord, only.
Then why you have indicated that matter is to be listed today in the list? 1st of December 2025.
Well, it
was filed on 26 November 2025. As per presentation from matter comes before me.
Lordship may kindly consider respondent number 1. The matter relates to Kolkata Port Trust. An employee who has embezzled.
Why it was not served upon Kolkata Port Trust? It is
Well,
5
Kolkata
minutes
Port
walking
Trust, my
distance
lord,
from here.
And that to
The
Union of
office
India
Kolkata
also.
Port Trust.
Yesterday, my lord, by hand service, my lord, I have.
Why? It was filed on 26 November 2025. Today we are on 2nd December.
My lord, my law clerk, my lord, was, my lord, suffering, my lord, from my lord, severe, my lord, cold and that.
At the time of call, accommodation is paid. You are for the state.
Lordship.
At the time of call, accommodation is paid for on behalf of the petitioner, since service of notice upon all the respondents is not complete. Next paragraph. State respondents are represented by learned advocates. Next paragraph. A learned advocate for the petitioner is directed to serve notice upon all the respondents by 10 days from date and file affidavit of service on the next date. List the matter under the same heading for further consideration. on 22nd of December 2025. Next.
Lordship. Lordship, may I seek your indulgence, Lordship? I just running our Lordship. Item number 21. Just your Lordship, reasons for default this matter. Lordship, kindly.
What can be done? No more
I'm just
prayer.
running Lordship sleep.
I generally do not allow this prayer.
Lordship, kindly. Lordship. Item number 21.
যেটা হয়েছে 21 দেখো তো 21 একটা dismiss for default হয়েছে ওটা not today করে দাও
Grateful, Lordship, grateful, grateful.
inform the other side
Lordship.
other side was there not today next occasion same prayer will not be allowed yes
Lord, I'm for the petition.
Item number 24.
I'm for the petition. This is my affidavit of service I've served. But this case is based on the Honorable Supreme Court's judgment in All India Judges Association, where it was stated that 3 years of experience is required as an advocate to participate in the civil judges examination that is regarding West Bengal Judicial Service 2023-2024, which has been advertised in 2025. Now, my lord, the only sole contention of this issue is that the 3 years requirement as a practicing advocate has not been adhered to in the recruitment procedure, which makes the whole process questionable. First, my lord, I draw your lordship's attention to the notifications.
but if this notification was issued prior to
No, there
enunciation of law by the Honorable Supreme
no,
Court
there is something very interesting that I'm trying to show. My lord, kindly come to page number 43, 5 for once. 45, 45.
yes
This is an indicative advertisement. Kindly see. The Commission will hold the West Bengal Judicial Service Examination 2023 for recruitment to the post of Civil Judge Junior Division in West Bengal Judicial Service. Detailed information regarding commencement and closing date for online application, age limit, qualification, scale of pay, fees through online and offline scheme, and syllabus of the examination, etc., will be available in the Commission's website at such and such. Before applying for the post, candidates are required to register themselves through the same website. Those who have already made enrollment through the same website earlier also need to register afresh. So it comes on 28th of December 2023. There are two, no, I tell you, Lordship, what has happened. Number, there are two such indicative notifications. Next page also. This is of 7th of December 2024, because there are two recruitment processes are being conducted simultaneously. WBGS 2023 and 2024, same language. Kindly mark, this is an indicative advertisement. Only a proposal has been floated. No details, no application, nothing. This is only an indicative advertisement. It's a proposal. Now kindly come to the advertisement at page
what
20.
proposal
I'm coming to
Commission will hold the West Bengal
Hold,
Judicial Service
yes.
2024 detailed information regarding age limit qualification scale of pay
Will be.
online scheme
It will be given.
and syllabus of the examination available in the Commission's website
Will be available. This is not an advertisement, what we are contending. Now kindly come to the actual advertisement, page 29.
your contention is restricted to 2023 or 2024
Both 2023, 2024, both. But my lord, kindly come to page 29. Kindly see, I'm placing it before Lordship, the first paragraph itself, in terms of commitment.
page 29
29. This is dated 13th of August 2025.
yes
In terms of commitment.
just a minute এই অঞ্জন শোনো yes yes
Page 29, my lord, kindly take the first paragraph. In terms of commitment before the Honorable High Court in item number MAT such and such, item number such and such, item number such and such. On
the date of advertisement
I'm coming to this. The detail, I'm coming. Well, kindly bear with me for
just a minute
13th of August 2025. That is at page number 35.
yes place it
Yes. First paragraph, in terms of commitment before the Honorable High Court in item number such and such, my lord, is given. This detailed advertisement is issued by the Public Service Commission West Bengal in continuation with the earlier indicative advertisement number 19 of 2023 and dated 20th of December 2023. The Commission will hold the WB West Bengal Judicial Service Examination 2023 in accordance with the existing rules for recruitment to the posts in West Bengal Judicial Services. The necessary particulars stated in the following paragraphs: a candidate should verify from the notified rules that he or she is eligible for admission to the examination. The conditions prescribed cannot be relaxed. So, my lord, they say that in continuation of the indicative advertisement. So they themselves draw a distinction that in continuation of the indicative advertisement. This is the first time the advertisement comes with all the details, all the requirement, eligibility, qualification, everything. Now, my lord, the All India Judges Association case comes in 20th of May 2025. Kindly come to page number 60, Roman 7. 60, 61, and 62. It's 60, Roman 7, 8, and 9. This lays down the procedure. Now, আস্তে আস্তে ধীরে ধীরে
Nine comes in favor of the.
Yes, now coming, it is not coming in it. 9 says those which has already been initiated. Now, To bypass this condition, they come with a further amendment. Kindly come to page 46, which is very vital.
Who has come with the
Commission. Kindly see what they are saying. Page 47. Just to bypass this provision of 3 years requirement of advocates. Kindly come. This is of 23rd of August 2025. They now understand. I'm sorry. I'm so sorry. There are two, my lord. Two notifications of each. One notification of each. 2023, 2024, both. Kindly.
Yes.
Page 47. Now they realize the situation. Now they come with an important announcement. With reference to the advertisement bearing number such and such, those are indicative, published on those are the real advertisements regarding West Bengal Judicial Service Examination and West Bengal Judicial Examination 2024 respectively. The following clarification may be noted by all concerned. In qualification clause, date of advertisement means the date of issuing indicative advertisement, that is 28th of December 2023 and 7th of December 2024 respectively. They become wiser. They come with this sort of important announcement. This is no amendment, nothing.
Who is appearing for the Public Service
I have
Commission?
one served. Kindly appreciates me, my lord. Now, my lord.
No, who is appearing for Public Service Commission?
Yes, I've served for Public Service Commission.
Mr. Piali Sengupto probably appears for Public Service Commission, because Public Service Commission is the authority
Absolutely,
who will initiate the process.
Absolutely.
The High Court shall notify the vacancies, identifying the vacancy and calculate the vacancy and notify it to the state government, and state government will forward it to the Public Service Commission.
Yes, my lord.
Public Service Commission shall initiate the process.
Yes.
So Public Service Commission has
Presence
to
is required. I have served, my lord. Only difficulty is 7th.
Piali Sengupto along with
Victor
Chatterjee. Inform them.
Only difficult 7th is date of examination. And my lord, only two things I would submit. I'm squarely covered by Amrit Yadav's judgment of the Honorable Supreme
No,
Court.
I'll not.
Of course.
I will not pass any order restraining this examination.
Very well. I'm not saying that, my lord. Kindly hears
there is Malik Mazhar's case.
Yes, that has been considered.
Exercise is required.
My lord, as per Tej Prakash Pathak clearly says, recruitment process commences from the issuance of the advertisement, calling for applications and ends with filling up of vacancies. Now, Amrit Yadav says any advertisement which does not give the requirements is not at all an advertisement. So, advertisement date comes from after this 20th of May of 2025 of this All India Judges Examination case. So, therefore, they cannot override the Honorable Supreme Court's observation. I'm squarely covered by Amrit Yadav and Tej Prakash Pathak. But 7th is the date, my lord. Kindly keeps it before 7th. Otherwise, I'll be in difficulty, my lord. I've clearly made out a case, and my lord, there's a prayer for interim order also.
Issue.
7th is the examination.
By presenting this writ petition. Who is the petitioner?
Petitioner is an advocate who is willing to take part to avail the benefit of 3 years experience. He has not participated in this because if he participates, my lord, he will be blowing hot and cold at the same time. He'll be taking benefit of the recruitment process as well as challenging the same.
Petitioner has not applied?
Because he will be losing the competitive edge, because he's an advocate. He has the benefit of 3 years practice.
So let him appear.
No, he will not get the benefit of 3 years.
That will be decided later on. Let him appear.
If he participates and challenges the same recruitment,
he has
taking benefit
prior to that.
No,
he has not applied.
No, he will not, because of the fact he cannot want to take the benefit at the same time to blow an hotel to reprobate and approbate. If he is strictly on his point that 3 years advantage has to be given to me. I'm a lawyer. I will not be considered for that at the final round. He's a practicing advocate. He is entitled for the benefit. And to have the competitive edge over others, those who do not have 3 years.
Question is this: petitioner is otherwise eligible. Petitioner could have applied.
But the competition he is not entitled to face the competition with others, those who are not having the 3 years eligibility.
By lodging a protest or representation, he could have applied.
At the same time, he is challenging this. He's challenging the whole recruitment process.
So that a year may not be lost.
No, he's challenging the whole recruitment process.
Petitioner is otherwise eligible. Why he has not applied?
He's
He
challenging.
wants to limit the
Absolutely.
extent of
Yes,
competition.
he has the right
can
for
be,
that.
That can be considered in connection with this writ petition. But for that petitioner, why petitioner has stepped out of the
Because, my lord, he's challenging
competitive examination?
He's challenging the whole recruitment process. That is why.
No, you are not challenged the whole recruitment process because recruitment has not yet started.
Yes.
Only your contention is this, that this qualification, that 3 years 3 years experience as a practicing advocate, which is a necessary eligibility criteria, has been left out in the advertisement dated August 2025.
That is an essential condition.
Yes.
That makes the redundant, that notification itself redundant against the Supreme Court's observation. Itself makes it redundant. And I'm challenging the whole process. If I participate, challenge at the same time, then, my lord, I'll be facing this question that why have you participated if you are challenging this? And, my lord, there are two exams. 2020.
What is the date of this advertisement?
There are two. There are two. 2023 and 2024.
2023, 2024. What is the date?
Date gulo bolo.
13th August 2025. What petitioner was doing
That is
for
for
such a long time?
2023. That is 2023.
No. Come to page 35. Final advertisement.
Yes. This is of
13th August 2025.
This is of there are two exams. WBGS 2023 and 2024. 2023, 13th August 2025.
And another is 28th December 2023. So what steps he has taken after 13th August 2025?
He's challenging the whole process. He's challenging.
After 13th August 2025, it is not there in the eligibility criteria that it is one of the essential conditions that a candidate must have 3 years experience as a practicing advocate of the court. But that's when this was not there, why petitioner has not come up? First thing. Second thing, if the petitioner is otherwise eligible, why petitioner has not applied? He could have applied with protest after making a representation to the Public Service Commission and High Court administration that is contrary to the law enunciated by the Honorable Supreme Court. He could have done this. Why he did not apply?
Firstly, 23rd of August, first time the notification comes that it would be changed. That would be considered. 23rd August. Yes.
December.
Yes.
Why he has not approached the authority and applied for the applied offering his candidature?
Because of the fact, Manoj, I said that I have challenged the whole recruitment process. I don't want to participate because it is completely against the Supreme Court's observation. I can show it from the records itself.
Very well, that could have been gone into, but you are praying for an interim order at the final stage when already all the arrangements are made and the examination is scheduled on 7th.
That is of 2023. No, that is for WGS 2023, not for 2024.
Yes, 2023.
2024 has not yet been published.
2023
Yes.
advertisement, final advertisement, according to you, that it's not tentative, but the final advertisement was published on 13th August 2025.
Correction came in 23rd August.
Yes.
Yes.
So August, September, October, November, these 4 months was
November
what
I
you are
filed.
doing.
November it has been filed.
What we are doing?
Yes, because it want to challenge and 2024 has not yet come into effect.
Stall the process.
But it is completely against the no. Kindly hear me out.
So far, this advertisement for 2024,
Yes.
no date is fixed.
Subject to correction, madam. Just taking instruction, madam. 2024 টা কি হয়েছে?
Judicial Service Examination 2024 date is fixed. Then
no, 2023 has given. 2024 says, I'm telling you, application is over.
Yes, application over, but no date is fixed.
No, application, the window is closed.
So 2023, you have not taken steps within time.
No, both published at the same time, on same day.
No, not on the same date.
No,
One
not
is
same
December,
time.
another in August.
No, 13th August is the
One
first.
is in December, Mr. Lahiri,
Yes.
another in August.
No.
Come to page 35.
35 is,
2025.
yes, that is of 2023. Kindly see the first page.
Yes.
19 of 2023.
So far, the advertisement,
But kindly take the advertisement number.
Advertisement is dated 13th August 2025.
That is of kindly 19 of 2023. That is of 2023.
Maybe.
And
But in connection with advertisement dated 13th August 2025, date of examination is fixed on 7th.
No. There are two. There are two. 19 of 2023 and 9 of 2024.
I am on date of advertisement.
On the same date, both the advertisement came for 2 years at a time. That's what I'm showing.
But another date is
kindly see 13th August, page 43.
43.
Both are on the same date.
Go to same date.
At the same date, they're conducting for 2023 and 2024.
Yes. So if it is 13th August 2024,
Yes.
why you have
2025.
not 2025? Why
Yes.
you have not applied? First of all, second of all, why you are coming at the fag end when the examination is scheduled on 7th? So far, 2023 examination is concerned.
Well, firstly, I submitted.
And you are pressing for an interim order at this stage.
So, not without hearing
You
the
could have
PSC.
you could have approached this court in the month of August, September.
That is
That
true.
is
my
what I am telling you.
Yes, that is true. But my lord, I am challenging the whole process. There is no point in participating in this because I will not be getting. I have every right to be treated with the competitive
After
edge at the
participation,
level
this
playing
point
field.
cannot be agitated when you are backed by a judgment of the Supreme Court.
No, it would be stated that you are taking advantage. At the same time, you are taking calculative chance. You could not qualify. You have come. I'll be barred by that.
That point cannot be taken in view of the judgment of the Supreme Court.
That is why I have come. Even I have a better case. I have come without participating, not calculating my chances.
You could have
I have come
applied and
before.
you could have made a prayer or a representation or deliberation that yes, I have applied, but these are the anomalies. So far, these two advertisements are concerned.
My lord, when it is ex facie bad in law against the Supreme Court's judgment, I subject to correction, my lord. I may not have to make a representation for their consideration. It is ex facie bad.
Representation, since you have applied for that, you are saying that if I had applied, if I applied for the in terms of this advertisement, then I would be debarred from lodging a challenge against this advertisement. To that extent, court is saying no. You could have applied pursuant to this notification and advertisement, and thereafter you made a deliberation before the appropriate authority, that is Public Service Commission and High Court, that this advertisement is in the teeth of the order passed by the Honorable Supreme Court.
If I wanted to participate in that, when the recruitment process itself is bad, I don't want to participate.
Second, you are coming after getting much time from August 2025. Now you are coming after
November.
30th of August in the month of November, December.
Yes.
And praying for interim order. What interim order at this stage will be passed?
No, the procedure has to be stopped because it is not in concern of the Supreme Court. Sorry, it is proved.
Who prevented you to approach this court in August,
My
September?
lord, I have approached before the examination. Examination is the appropriate date. I have approached before examination of 7th of December. So for 2023 is concerned and 2024 dates
So
are
therefore, you can come at least even one day before the examination.
No, certainly not. If it is
that is what has been done.
It is not.
After making the writ petition ready for hearing, today we are on 2nd of December. Examination is scheduled on 7th of December. You are praying for
2024, I can
So
challenge.
you had enough time from August 2025.
Then so for 2024, I am eligible to challenge that if it is not at the teeth of just clocks hour before the examination. 2024 is in then my favor, my lord.
Yes.
2024, I have come. Regarding
2024
2024,
date is not fixed. Matter is to be heard.
that is
so far 2024.
yes. So for 2024, I am in advance at the right time. I have come before your lordship for 2024. So for
the
2024
question
is
of
concerned.
passing any interim order in 2024 does not arise.
No, in that
Because no date is fixed.
No. Kindly see the notification. Kindly see the notification.
In 2024 advertisement, is there any date fixed for a written examination?
Page 42. No, kindly take page 42.
In 2023, 7th is the date fixed.
Yes.
In 2024, no date is fixed.
My lord, the date of commencement of
So
submission
what is
of
the scope of question of passing an interim order?
may I propose a question to myself that at what time should I come before your lordship? For 2024, I have come much
In the
prior.
month of August
2023. No, my lord, I have time before the examination. I have come.
First of all, you are eligible. You did not apply. Second, you are coming in the November, December in connection with the advertisement of August 2025.
My eligibility is clouded and shrouded by this notification which I have challenged thoroughly throughout. That is why I don't want to participate. It is not legal. It is against the Supreme Court's observation. Kindly see. November 18, the window closed for 2024. When it is ex facie bad.
Yes, what is the stand of the High Court?
Clause 9 of that judgment that my learned friend has
Yes, that I have seen. But
what
whether will it be considered as an commencement date of the selection process, that indicative advertisement?
My lord, if the High Court has initiated if your lordship considers that the High Court has initiated the ballot selection process by my lord sending the vacancy, if that is the date of initiation, my lord, then my lord.
How can it be? Because subsequently, when the advertisement was issued, then the Public Service Commission had ample opportunity to implement the order of the Supreme Court.
To implement the order of the Supreme
So
Court.
why the steps are being taken to avoid the order of the Supreme Court?
Best authority, my lord, is the PSG to, my lord, to clarify this point.
Question is that it was decided by the Honorable Supreme Court in the month of May, 20th of May 2025. There were two indicative advertisements in 2023-2024 relating to two selection process of 2023-2024. Now, ultimately, final advertisement was published on 13th August 2025, detailing the eligibility criteria.
As well as
so
the
when the eligibility criteria were fixed, was it not the duty of the Public Service Commission to incorporate the observations or to follow the observations made by the Honorable Supreme Court in the order?
That is here for your lordship to, my lord, kindly to adjudicate. Because
ultimately, court wants to see that if it is a fit case, order of the directions of the Honorable Supreme Court should be given effect to. Should be given effect to. But while publishing advertisement, why why the incorporations were not made, appropriate incorporations were not made?
The Public Service Commission.
It should have been inserted in the advertisement in consonance with the observations and directions contained in the judgment dated 20th of May 2025.
But then
why steps are being taken to in such a manner that not to follow or to bypass the order and observations passed by or made by the Honorable Supreme Court?
That is page 47. Where, my lord,
I could understand that prior to that, the final advertisement was published.
That is page 47, where they are trying to, my lord, indicate that the date of advertisement
in
is
your
the earlier.
Yes, in your previous advertisements, nothing has been stipulated.
Neither vacancy nor eligibility criteria.
Nothing.
Only
They say the commission will hold the West Bengal's Judicial Service Examination 2020 for recruitment to the post of civil judge. Detailed information regarding will be available.
Yes.
Now, will be available. It was ultimately made available when?
In 13th August.
13th August. By this time, judgment has
come. The only
so the bona fide approach should be to follow the judgment of the Honorable Supreme Court, not to avoid it, not to evade those observations as contained in the judgment dated 20th of May 2025.
That should have been the approach, to my humble understanding. But my lord, here only one thing, my lord, at page 45.
Yes, petitioner has made delay in approaching this court, but that does not obliterate the situation or obliterate the responsibility of the Public Service Commission to follow the guidelines or the directions as contained in the judgment dated 20th of May 2025.
The mandate of the Supreme Court.
The objective of the should be to follow the judgment, not to bypass the judgment.
But in, my lord,
not to obviate the judgment.
On December 2023, when they are, my lord, issuing this indicative notice for 2023 recruitment process, they are saying that before applying for the post, candidates are required to register themselves. So the process of registration was, my lord, initiated. This is the only thing that I have found in the 2023 recruitment.
Where?
Page 45.
Yes, page 45.
The last para. Lord, before applying for the post, candidates are required to register themselves.
Before applying the post, candidates applying must be in terms of the advertisement dated 13th August 2025.
In terms of certain eligibility criteria.
Yes. So therefore, registration, it is not a case that where registration was made or registration was permitted prior to 20th of May 2025.
Well, that cannot be because, well, there was no...
Because the final advertisement stipulating the eligibility criteria was notified on 13th August 2025. If that be so, then why the judgment of the Honorable Supreme Court was not taken care of?
Well, ought to have been, but that is my humble understanding.
What is this? He will serve notice upon PL Sengupta. Matter is heard, tomorrow it will appear again.
I'm sorry. The order, let it be with your lordship's record.
Yes. And matter is heard at length in presence of the learned advocates representing the petitioner. High Court administration and state respondents. Stop. Court desires to hear West Bengal Public Service Commission. Since it is argued on behalf of the petitioner, while issuing final advertisement dated 13th August 2025, advertisements dated 13th August 2025 for conducting West Bengal Judicial Service Examination 2023 and West Bengal Judicial Service Examination 2024. Directions of the Honorable Supreme Court as contained in paragraph 89 within bracket Roman 7 small, 89 within bracket Roman 8 small, comma, কি বললাম সেমিস্টার বল (4) in the judgment dated 20 May 2025, delivered in the writ petition within bracket C, close bracket number 1022 of 1989, within bracket All India Judges Association and others, plural, apostrophe, All India Judges Association and others versus Union of India and others. Stop. Next paragraph. Learned advocate representing the petitioner is directed to serve notice upon the learned advocate representing West Bengal Public Service Commission or Public Service Commission West Bengal. Public Service Commission West Bengal by in course of this day. Stop. Hearing of this matter stands let the matter appear under the same heading for further consideration tomorrow, 3rd December 2025.
With regard to 2023 and 2024.
Active petition. Affidavit of Amrit Yadav holds on the same line.
There has been
Amrit Yadav holds on the same line. Any recruitment notification does not bear anything, is not at all a recruitment notification.
There has been a further
I'll place it
clarification
tomorrow.
of this judgment on 18th of November also.
What is troubling this court is that this notification was not an exhaustive notification in 2023.
No, it was not.
Final notification advertisement was published on 13th August, delineating eligibility criteria. Then why the eligibility criteria which was required to be indicated in terms of the judgment dated 20th of May 2025 was not incorporated?
Other states have followed. I will place it tomorrow. Other states have followed it. Two other states
There has been another clarification also on 18th of this month of the same judgment, which opens a new way, but that is not under challenge over here. It is with regard to persons who had 1 year or less than 3 years of practice, now serving as judges, and they want to enter into the service of another state. There, the Supreme Court has been pleased to clarify that for them, the 3 years practice will not be required, but 3 years of service will be required.
It is different.
In that case, it was 6 years of
Amar
service.
case সাথে তো
And
নয়
further
এটা।
clarifications are also being made as we progress.
Not connected with my case. Grateful to your lordship. Much obliged.
Item number 25. Your Lordship, in this matter, the counsel appearing for the petitioner.
Who is appearing?
The advocate Deepan Banerjee.
Yes.
Subject to Lordship's kind sanction, my lord, may I submit one thing?
Just a minute.
My lord.
Order one. Just go to.
বইটা দাও বইটা দাও কমিশন সিলেকশন স্টাফ সিলেকশন কমিশন
Last occasion, nobody appeared. Today, why you are praying for time?
Your Lordship, actually the
Last chance, it is stated that if on the adjourned date the petitioner goes unrepresented, consequences. But now today, why you are praying for time? Last occasion, nobody appeared for the petitioner. Union of India was represented.
Your Lordship,
Where is he?
Your Lordship, he had to go to Bombay due to his personal inconveniences. He had to urgently leave for Bombay. So we are praying for a fortnight's time, Your Lordship.
Only.
Only.
Very well, pay 15,000 rupees to the concerned answering respondent for getting 15 days time. Then matter will be taken up according to the convenience of the learned advocate.
Your Lordship, he had to leave us.
Yes, I will grant time, subject to payment of 15,000 rupees to the concerned state answering respondent. Last occasion they appeared. Nobody appeared for the petitioner. Today you are appearing, praying for time. Is it a matter of right?
Your Lordship, Your Lordship, I'm actually a new joinee. I was not conveyed any information about this
What
matter.
can be done? You are appearing for the petitioner. Court has to express its mind. Irrespective of your standing at the bar. Last occasion time was taken and today you are praying for fortnight time. Very well, I will grant fortnight time, pay cost of rupees 15,000.
Or even
per day 1,000, not much.
Or even, Your Lordship, a week's time is okay.
Yes.
Your Lordship, even a week's time is okay.
So why you are praying for fortnight time? Even a week's time is okay. Don't say okay before this court. It's not a word to be uttered before the court.
Sorry, Your Lordship.
Yes. It is not your drawing room. What is the matter about Mr. Banerjee?
My lord, it's directly, my lord, hits the section 14 of the Central Administrative Tribunal Act. My lord, it has to be preferred before the Central
Tribunal. Yes,
and that is last, my lord, when this point was taken, since then, my lord, they are not appearing. That is the issue.
Where petitioner was working?
My lord, they have, my lord, applied for the recruitment post. Subsequently, my lord, they have been denied as, my lord, the cut-off marks, they could not qualify. Now they approached this honorable court.
Cut-off marks relating to a selection process. For appointment appointment in which post, in which organization?
My lord, it is directly Government of India. My lord, Staff Selection Commission through Staff Selection Commission, Group C.
Show me the notification relating
yes,
to
that is, my lord, within the petition, my lord, if you lordship.
Please to supplementary affidavit on behalf of the
Lord, page 12, my lord, if your lordship kindly sees page 12 of the supplementary affidavit filed by us. My lord, that is, my lord, it was
Page 12.
Page 12 of the supplementary affidavit affirmed by us, my lord. That is, my lord, it was affirmed on
combined graduation level.
2nd July
2nd July
2025.
Yes, yes. Supplementary affidavit.
And my lord, it starts from page 12, my lord, the combined graduate level examination 2020.
2nd July 2025. Yes, page 12.
Yes, my lord. My lord, that is the notice, my lord, that was issued by the Staff Selection Commission.
Where is the description of post?
Yes, my lord. That is, my lord will get এইখানে আছে ABCD বার করো হ্যাঁ
Page 13.
পেজ 13 না পেজ 13 না ওই লাস্টের দিকে দেখো ইয়েতে দেওয়া আছে Yes, my lord will get from page 13 also.
13 following
Page
line.
13, 14. Theta 13 and 14. And the detail of vacancy, my lord will get from the page 81 onwards. Directly, my lord, that is direct recruitment.
And the petitioners are desirous to be appointed in which post?
In group C.
Group C.
Group C and group D. My lord,
Where the
according to
group C and group D
Group
advertise?
C and group D, my lord, is subject to your lordship's kind sanction. If I say that group C and group D, peon and clerk, not that. My lord, group C and group D, they have, my lord, made it. My lord, I am showing. Because there is a module 2, section 2. কোথায় আছে দেখো? বার করে দাও এটা এই পেজটা একদম শেষের দিকে থাকে
The posts are indicated in this 1, 2, 3, 4.
Yes.
Inspector post.
My lord. Yes, my lord, page 125, my lord, if your lordship kindly come to page 125, that is the list 2, B, thereafter, my lord, C, B and D. Because it is related to the, not related to the C. For such reason, my lord, we have not annexed. Page 125 to 120, my lord, 8. 128 B category and my lord, D category, page 129 below.
128.
28. Up to 128, my lord, category B, and after, my lord, to page 129 at the, my lord, bottom, it starts D0102 post. And my lord, the more particularly, my lord will get from page 13, they are in group B, group D has been defined.
Page 30.
13, 1-3. My lord, it has been defined.
Where?
Yes, page 13, my lord, kindly see, assistant officer, section, central.
Against which serial number?
My lord, against 1. My lord, I'm just reading page 13, 1. But for example,
section.
Assistant officer section will be Central Secretariat Service Group B. That has been denoted as a Group B. Now, my lord, Assistant Officer Intelligence Bureau Group B. My lord, directly it has been defined, and ultimately Group C. My lord, that is, my lord, next page, Auditor.
Inspector of Income Tax CBT Group C.
Group C.
Classification
That is then been classified.
And they are seeking to be appointed in Group C and Group D.
Group D. Group B bola. Group C na.
Group D, কিন্তু D.
না ঠিক আছে D. And there is a, my lord, my lord, the main prayer is that, my lord, in the written examination, he has been declared as qualified. Thereafter, my lord, test examination is there, that is the typographical. Now, the error has been committed, my lord, by him, is 19%. Tolerance is there, my lord, not more than 5% to 5 to 8%. For such reason, his candidature has been denied. That is data speed entry test.
Issue. Matter was taken up for consideration on 6 November 2025 when one appeared for the petitioner. Stop. By passing order dated 6 November 2025, court fixed the matter for further consideration. Now, court directed the matter to appear under the heading motion on 19 November 2025. Stop. Today, matter is called on when accommodation is prayed for on behalf of the petitioner and same is refused. Next paragraph. Union of India is represented by Union of India is represented by Mr. Othurup Banerjee, learned advocate, who submits that writ petition is not maintainable at this stage before the Honorable High Court, as the petitioner has ventilated grievance relating to the selection process for being appointed in the post under central government. Stop. Next paragraph. Next paragraph. Court has perused the recruitment notification which was uploaded on the website on 24th June 2024. Stop. Stop. It appears that selection process pertains to posts under central government, and if post under the central government. Stop. If petitioner has grievance relating to conducting such selection process, he is required to approach Central Administrative Tribunal. Next paragraph. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to approach Central Administrative Tribunal with the self-same cause of on the self-same cause of action. Parties to act on the server.
My lord, I tend my unqualified apology. Yesterday, one matter was been taken up by your lordship, in which the scheme of the my lord compassionate appointment, my lord, ultimately my lord has dismissed the writ petition, but because the scheme has been produced probably my lord to London Junior, my lord, that was their indication. Right, and I could not have. One Rohingya matter was going on for such reason, my lord.
Item number 21 from monthly list.
I am appearing for the petitioner, my lord. In this matter, my lord, I have served upon all, in terms of lordship direction, I have served upon Mr. Galib and also other respondents, my lord. My lord, the matter relates to appointment of supervisor in ICDS project.
But
My
in
lord,
absence of other side, how I can hear the matter?
my lord, in other matter, my lord.
Show me that you have informed Mr. Gali.
Yes, my lord.
That is the old service.
No, my lord.
Yesterday matter
No,
was
no, my
taken
lord.
up.
No, my lord. In
Yesterday
terms of your lordship direction, my matter is fixed on 1st December.
Yes, yesterday matter was taken up, nobody appeared. Did you inform Mr. Gali?
No, my lord.
Is there anybody who appears for the state respondents? Mr. Lahiri, inform Mr. Gali. In one matter, he is appearing for the state, but repeatedly matter is being called on, he is not appearing. Inform Mr. Galib that tomorrow matter will appear. This is item number 21 of the monthly list. Tomorrow matter will again be taken up.
My lord, day after
Inform him
tomorrow.
to appear.
Day after
Yeah, not today, not tomorrow, and Wednesday.
That's right.
On the Thursday.
Thursday, I mean for
Item number 26.
My lord, Ms. Samajpati is appearing for the Life Insurance Corporation of
Who
India.
is
my
appearing
lord.
for the petition? Yes.
My lord, she has come to the court, but due to some immediate family emergency, my lord, she has left the court, my lord.
But it is that matter, my lord, where there has been, my lord, the deduction is being made.
My lord,
Not today. Not today.
Item number 27.
Madam, Mr. Supratim Dhar is appearing for the petitioner in this matter, madam. Due to some difficulty, he has left court, madam. I'm praying for an accommodation of.
Everybody has personal difficulty and living court nowadays. Previous matter also left the court.
Today is only fixed for taking instruction from his client.
Just a minute. That matter. You are appealing for the petitioner? What is the instruction? That why he did not appear on 29th of May 2025? You are Abhishek Chakraborty?
No, ma'am, I'm not.
No, Kaustav Banerjee?
I'm.
Yes. Tell me that why petitioner did not appear on 29th of May 2025. In spite of opportunity was given to the petitioner to appear before the area medical officer, Bankola area.
My lord, as of now, I have no instruction, my lord, regarding the petitioner's presence. I have no instruction.
Then nothing can be done in this matter. Let me dismiss the writ petition.
Kindly grant an
No,
accommodation.
I have passed order on 11 November 2025.
My lord, Mr. Shukla.
For that, Mr. Dhaw's presence is not required. Question is this: why the petitioner did not appear on 11th, on 29th of May?
My lord,
The reason of his non-appearance is he has stated in his letter, which we have deposited.
Where is that?
Third page of the letter which I have given to your lordship. He says, I have filed a writ application, so I will not appear.
Which page?
Third page of the document which I have handed over.
Last occasion you have any?
I have handed over a 3 pages document, lordship. Yes, lordship, the third page of
No document is on record.
Oh. So this is the document which I handed over to them and the court provided. Court said to come back with the instruction.
Due to pendency of this matter, we will not.
My lord, kindly grant an accommodation for Monday. My lord, tomorrow, my lord, Mr. Dhar will be present. My lord. Kindly, my lord.
To fix up another date, fix up another date when petitioner will appear. Whether the petitioner is ready to appear before the authority.
Lordship, let him.
Let him not to ask Mr. Dhar to come to
my lord. I'm grateful.
In this manner, matter cannot. Take it back, okay? Copy it here. Produce it on the next day.
Lordship, my advocate on record is saying kindly pass an order and take this on the record. That might.
No, since tomorrow I am matter will be taken up
for other purpose.
No, that I know.
As your lordship.
Come back tomorrow. If matter is not signed today, then there will be a difficulty in placing the matter in tomorrow's list.
Item number 28.
28, I am for the respondent, was it?
For the petition.
This is not maintainable before the court.
Yes.
It is not maintainable before the High Court because the central administrative tribunal, the proper forum. The issue relates to entitlement of family pension of the second wife.
You are appealing for?
Respondent, my lord.
Which respondent?
1, 2, my
lord. Of India?
Yes, 1, 2, 4.
So, according to you, this petition is not maintainable at this stage?
Yes.
Why?
Because, my lord, they're claiming the family pension of second wife.
Husband was working where?
Husband was a civil defense at Ishapur gun factory.
Yes.
So it is central service, my
lord. Which post was held by the husband?
Audit post, my lord. It is
Where
under.
you have stated?
He is in the principal controller of defense accounts. The office was principal controller.
Where from you are getting this, Mr. Ladi?
Paragraph the first respondent in the cause title and the paragraph 3, তাই তো 3 তে লিখেছেন
Paragraph 3.
paragraph 3 তো এটা 2 তে তো এটা লিখেছেন
Paragraph 3 is not there. What promotion? The number basically নেই আমার কাছে। আমার কাছে নেই। নেই। আমার কাছে নেই। আমার কাছে নেই। ছিল বলে।
He was a selection grade auditor. In which department?
Principal Controller of Defense Accounts.
Principal Defense.
Principal Controller of Defense. Principal Controller that has
Respond number 2, my lord.
respond number 2
Issue.
is a family pension. Rule permits that the second wife is entitled for.
But forum is,
He cannot overlap the forum.
for that court needs to enter into the merit of the case.
Yeah,
That
yes, yes,
that
I-
is not permissible at this
Yes,
stage.
yes, I leave it to law.
L. Chandra Kumar.
Liberty may be given.
Yes, yes.
When?
At the time, at the threshold, learned advocate representing Union of India has questioned maintainability of this writ petition before this court at this stage. Since husband of the petitioner was holding the post that is selection grade auditor in the office of principal controller of defense accounts, pensions. No, that is stationed at Allahabad. Respondent number 2. Where the husband was working in West Bengal must be.
West Bengal. Controller of Accounts. Respond number 3. ঠিক বলছেন? দেখে বলুন আমাকে দেখে বলুন।
আচ্ছা কি বললাম সেন্টেন্সটা বলা।
This is it is written because during pendency of the writ petition this order was issued rejecting the claim.
As the
দেখি কি আছে হেডিংটা দেখি। এই যে প্রিন্সিপাল কন্ট্রোলার অফ ডিফেন্স অ্যাকাউন্টস।
So and so under principal controller of defense accounts, pensions being respondent number 2.
Kindly see that.
Stop.
Written at the top. Principal Controller of Defense Accounts, Kolkata, who has rejected the claim, the petitioner. So this
Under
is
principal controller of defense accounts, Kolkata.
that much. Respond number 3.
Respondent number 2 টা কেটে দাও। Stop. Next paragraph. This court finds substance in the submission made on behalf of the Union of India as the husband of the petitioner was working under the central government. Writ petition at this stage is not maintainable before the High Court. Next paragraph. Petitioner is represented by learned advocates. Next paragraph. Writ petition stands dismissed as it is found not maintainable. Stop. However, this order shall not preclude the petitioner to approach Central Administrative Tribunal on the self-suit cause of action. Parties to act on the server copy of this order duly downloaded from the official website of the school. Next. পিটিশনারের হয়ে যেটা অ্যাপিয়ার করলো তার ওই ছেলেটির নামটা কি দিও? হ্যাঁ,
Item number 29.
I am appearing on behalf of Union of India.
From petitioner.
You are for the petitioner?
Yes, ma'am.
My lord, the writ petition is already infractuous because my lord, he has challenged, my lord, your lordship kindly see, he has challenged, my lord, the transfer process. My lord, already he has taken transfer and joined in the new post at Bilaspur.
Yes.
My lord,
What remains?
my lord,
this is case of 80% disabled CISF personnel. And my lord, transfer order was issued and
But the transfer order has been implemented.
order has been implemented, but my lord, when the transfer order was issued, a condition was there that those who aggrieved with the transfer order will make representation which should be disposed within 15 days. I have submitted representation on 7/4 within the time. That has not been disposed within the stipulated.
Where is your
period.
representation?
My representation is, my lord, at
That representation is already considered and rejected. This is the order.
my lord, till my representation is at page 17. And transfer order is at page 12.
Transfer order page 12.
At page 12, condition is there, representation, if any, against the posting order are to be disposed of within 15 days.
Transfer order dated 4th April 2025.
Yes.
Which clause you are relying upon in the transfer order?
6, clause 6, my lord, at annexure P2. And my lord,
at which serial number petitioner's name is appearing
21
at page 13?
21. Last part 1. Serial 21.
Prior to that, he was posted where?
Darjeeling.
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 And my lord, he relieved.
When you have made this made a representation
on 7/4.
7/4. Yes, it is within. It has not been considered.
Not considered, my lord.
Not been considered.
Yes, yes.
My lord,
Rejected.
my,
Show me that how
order
that
is
is
with
considered.
me.
my lord,
That order is with me, and the reason for rejection, that is also with me. Your lordship, kindly see page 2, last paragraphs onwards, page 3, serial number 6, and my lord, the order is, my lord, page 9.
Page 2 and page 9.
Page 2 and 3.
2, 3, 9. Page 2
and 3. Why his prayer was rejected? The
and
reason.
page 12.
Page 9 is the order considered and rejected, and page 2 and 3 for reason why it was rejected. না আপনার আগেই চলে গেছে। Prior to passing, my lord, the rejection order, he has already joined. In the month
Before
of
rejection order.
yes, in the month of
Rejection order was passed on 16 July.
yes, in the month of June, he joined. at Bilaspur. Your Lordship, kindly see page that is also in page 6.
Just a minute.
Page 2, serial number 5, and page 3, serial number 6.
It has been decided, your representation has been rejected by supplying
my
reasons
lord,
which is dated 30th July
my
2025.
lord, with your permission, I want to submit that my date of relieving was 1st May 2025.
Your date of
And
representation.
my lord,
No, your date of representation is dated 7th April 2025.
Yes, my lord. But on 1st May 2025, I was intimated by department that your representation is pending with higher authority. So your relieving order is
1st May 2025.
Yes.
No, subsequently this order was passed on 16th July 2025.
But petitioner has not got the disposal.
Issue. In the writ petition, transfer order of the petitioner dated 4th April 2025 is questioned. Stop.
My lord, 4th April as well as 16th April. Both are challenging.
16th page.
16th April, page, very next page, annexure P3. P2 and P3 is.
It's a list.
Yes, both are.
4th
My learned
April
friend has
2025
challenged.
is challenged. Whereby 4th April, whereby petitioner was transferred to ACCL Bilaspur. Stop. However, next part. However, during course of hearing, it is submitted by the learned advocate representing Union of India that petitioner has joined the post where he was transferred. When joined?
2nd July. July.
So, he has released, my lord, on 19th of June, and it will be taken, my lord, on consideration on 20th June onwards.
When joined the transferred post?
He joined the transfer port on 2nd July, my lord. And it said
7th July 2025.
Transfer post was 7 July 2025. Stop. Therefore, it is contended on behalf of the respondents that writ petition has become infructuous since transfer order has already been given effect. Next paragraph. Learned advocate representing the petitioner submits in terms of clause 6 of the transfer order dated 4th April 2025. Clause English 6. Clause 6 of the transfer order dated 4th of April 2025. There was a provision to make a representation against. There is a provision to make representation there against. And accordingly, a representation was made on 7th April 2025 against the state transfer order, against the aforesaid transfer order. So, petitioner prays for consideration of such representation dated 7th April 2025. Next paragraph, in reply, it is submitted on behalf of the petitioner that petitioner's representation dated 7th April 2025 was turned down. VDA communication dated 16 July 2025 and reasons for not accepting the prayer of the petitioner as made VDA representation dated 7th April 2025 were communicated by a subsequent letter dated 30th July 2025 issued by Commandant/AIG Legal, FHQ, New Delhi, Central Industrial Security Force. Stop. Next paragraph. Copies of communications dated 6 July 2025 and 30th July 2025 are filed before this court and same are taken on record. Next paragraph. It is found that though petitioner made representation within time against transfer order dated 4th April 2025, but same was rejected. VDA 2 communications dated 16 July 2025 and 30th July 2025, no relief can be granted in this writ petition. Moreover, it needs to be recorded that in this writ petition, those two communications dated 16 July 2025 and 30th July 2025 are not questioned. Stop. Writ petition stands dismissed. Urgent direction.
Don't take me amiss, Lord. But item 27, Mr. Thor has requested just now. But your lordship has been pleased to pass over for the day. But he will not come tomorrow, Lord, if it is day after tomorrow.
Yes.
Item 27.
Yes.
Instead of tomorrow, day after.
Don't mention Mr. Banerjee now.
No, I'm not mentioning. Just now he has requested me.
Yes.
Mr. Thor is ground, your lordship has allowed for the day adjourn. Lord, he has requested me to place with your lordship. Lord, your lordship, don't take
Who has requested you?
Mr. Thor, Supratim
Yes.
Thor. From LRTT, he has requested me.
No, sorry, I am not satisfied with the conduct of the advocate. I will not pass any. I will not grant any further time. Today, this court was inclined to pass an order. Sorry.
Tomorrow he will not come. That's why I'm not day after.
Very well, then I will pass an order. Sorry, Mr. Banerjee. Yes. Previously, time was granted, and there was a direction to obtain instruction.
No, your lordship, he has already taken instruction.
Tell him that court has requested him to appear in this matter. Yes. Yes, next matter.
Item number 30.
Okay, item number 30.
Obliged, your lordship. If your lordship so desire,
Item number 30, Mr. Dibendu Chatterjee is appearing for the petitioner lordship. He has left court lordship due to personal difficulty lordship. Playing for just not today.
This matter I am appearing for the state, my lord, along with my junior.
You are appearing for the petitioner?
Mr. Dibendu Chatterjee is appearing for the petitioner lordship.
Yes. You are praying for time.
Not today, just.
Not today.
Item number 31.
I have a CAN application, my lord, in this matter. My lord, kindly see, my lord, the interim order which was passed. Page 22, my lord, of the
Who is appearing for the other side?
Mr. Colonel Basu was there and Khali Colonel can অনেকে ছিল তো উজ্জ্বল ছিল বাইরেই দাঁড়িয়ে আছে তো উজ্জ্বল।
Mr. Basuman.
Lord, very, my lord, short point involved. My lord, kindly have a look at the order at page 22. Lord, the application has been filed by LIC. My lord, the development
Page 22,
of the
22
CAN,
of
my lord.
application.
Yes,
CAN.
my lord, this was the first order. My lord, after my lord hearing the parties, my lord, of 24th June 2025.
Yes.
Now, my lord, the challenge in the writ petition is to the amendment, my lord, to the rules, my lord, governing, my lord, the development officers. The amendment is of 2016. The vires of that amendment, my lord, had been challenged. And my lord, on the basis of the amendment which was introduced, my lord, the efficiency, my lord, of the concerned development officer was found, my lord, to, my lord, fall foul of the rules, which leads to, my lord, in effect, my lord, automatic termination unless it can be shown that the calculation is wrong. So, my lord, the vires, my lord, was challenged, my lord, of the rules, and kindly have a look at the order. My lord, page 22. My lord, the two reliefs which are asked for D and E, my lord, of the writ petition, my lord, are, my lord, set out. Then, my lord, kindly come to, my lord, after that, page 2, my lord, 29, my lord, running page, or 23, claiming identical relief. Several writ petitions are pending in which diverse orders. One such order was also passed by this court in so-and-so. Mr. Kollol Basu, learned counsel appearing for the petition, has drawn attention of this court to an interim order passed by a coordinate bench. LIC has preferred an appeal from the same. Appeal was disposed of with the following observations. Then, my lord, in view of the above, an interim order was passed by this court on April 10 to the effect that proceeding against the petitioner may continue, but no final order shall be passed. Proceedings shall abide by the result of the writ petition. Parties were directed to exchange affidavits. The said order dated 10th April 2025 also noted pendency of a special leave petition. Today, when the matter has been taken up for consideration, Mr. So-and-so, to have both submitted separately, but the submission has been echoed. They submit that in the meantime, by a judgment dated December 20, bunch of writ petitions, Allahabad High Court in New has held the subject rules to be inter vires. Both the learned counsel appearing for the respondent submit that the subject rules which are under challenge in the instant writ petition were the same rules which were under challenge before the Allahabad High Court, and the same was declared to be intra vires. Copy of the judgment of the Allahabad High Court placed before this court is taken on record. Several writ petitioners who were there before the Allahabad High Court being aggrieved by the said judgment preferred special leave, copies of bunch of orders. My lord, the last order, now there is a further order, my lord, which I can, my lord, place. Page 26 now. My lord, second para, referring to these orders passed by the Honorable Supreme Court, both the learned counsel for the respondent submit that operation of Allahabad High Court judgment has not been stayed, and therefore there is no scope for passing any further order in the instant writ, since the rules under challenge have already been declared. Is further. Then, my lord, after all this, after considering the rival contentions of the parties and upon perusal of the materials on record and records placed before this court as referred to above, it appears to this court that 1. None of the orders passed by the Honorable Supreme Court show that stay was pressed for but refused. Simply the hearing of special leave petition was adjourned from time to time and scheduled to appear in so-and-so. In view of the above, since the issue is pending before the Honorable Supreme Court, judicial propriety demands that hearing of this writ petition should be adjourned for the time being until the issue is finally decided. Lord, I have no problem with this. Then the next, the same interim order passed earlier dated so-and-so can continue for the time being. Accordingly, the proceeding against the petitioner may continue, but no final order shall be passed by LIC. This writ petition shall appear. Now, my lord, we challenge this order. বসো বসো
এখানে যে টানবেন
হ্যাঁ বসো 5 মিনিট ধরো।
5 মিনিট 10 মিনিট
হ্যাঁ ঠিক আছে হুম।
কি করবেন এই ছেলেটা খুব ভালো ছেলে। Yes.
Now, my lord, from this we preferred an appeal from this order. Kindly have a look at the order, my lord, at page 28. Kindly see para 3. During the course of hearing, learned counsel for the parties reached to a consensus. It is agreed that the appellant may be permitted to withdraw these intra-court appeals. My lord, 3 writ petitions preferred against the order dated so and so, respectively, with liberty to file appropriate application seeking modification of the said order based on the judgment of Supreme Court. The other sides have no objection. Appeal stand dismissed as withdrawn with the liberty as prayed for. It is made clear that this court has not expressed any opinion on the merits of the matter.
Mr. Mukherjee, in the meantime, Supreme Court has issued notice
Maybe.
on 24th of
My
November.
lord, it's a virus matter. It's normal for Supreme Court to issue notice. But my lord,
At this stage, court is not inclined to.
kindly provide that, my lord, so that I can take it up higher. My lord, I have come
Because I have
because
come across this order passed by the Supreme Court on 24th of November 2025.
my lord, I have it here, my lord. I was going.
That I know.
Yes. So, my lord, as I said, my lord, the important thing is today, my lord, the virus, my lord, challenge to virus,
Failed before the Allahabad High Court.
that is binding pan-India. That's the Supreme Court judgment I want to say.
That is under challenge before the Supreme Court.
Maybe then don't hear the writ
Not
petition.
dismiss the.
No, then I will,
SLP.
my lord, if, my lord, that is the case, that because it's pending, then no order should have been passed. It should have been adjourned. That's my respectful submission.
In that event, what would happen to the development officers against whom proceeding has been initiated?
Yes. My lord, my lord, as of now,
Since she wants vacation of this order, he says that the court should stop here and then Miller the.
my lord, there are 2 limbs to the order. One is I will not hear the writ
I
petition.
remember the specific submission made by Mr. Mukherjee on last occasion, though it was not a detailed hearing, that nothing will happen before the Supreme Court on 24th of November. But that is not
My
the.
lord, nothing will happen on the 20th. I can wager, my lord. I can wager. Nothing. My lord, Supreme Court is also, my lord, bogged down. My lord, today, my lord, kindly, my lord, consider, my lord, my lord, decision. My lord, I have, my lord, my appeal was scattered, saying, my lord, when I cited, my lord, Kusum Ingots, that it wasn't cited, my lord, before the learned judge. So you please go back and cite it. Parties agreed. So let me cite it. After that, your lordships, my lord, at least, my lord, we can, my lord.
What is the use of such exercise in view of the issue pending before the Supreme Court, and Supreme Court directed to issue notice and fix the matter?
My lord, kindly say that, my lord, the application has become infructuous. Kindly say that. If your lordship holds that, I have nothing. But my lord, I went up on appeal.
No, why I will hold at this stage that the application has become infructuous?
No, my lord.
Let the application be
Then
kept
kindly.
pending.
No,
Yes.
then, my lord, let me cite
Till
Kusum.
the issue is decided by the Supreme Court in connection with
My
the
lord, may I
pending
make a,
SLP.
my lord, may I make a respectful prayer? My lord, LIC, my lord, is bearing, my lord, costs only in West Bengal to maintain development officers. My lord, everywhere else they have accepted it. Now, my lord, I can understand your lordship saying, well, they are inefficient, but if the rules are bad, they are very efficient. My lord, that could be a view. And that issue is pending before the Supreme Court. Now, my lord, the fact of the matter, my lord, is that, my lord, I went up, my lord, to, my lord, the division bench. Division bench, parties agreed that I'll be allowed to cite this. I'm not saying what order your lordship will pass.
Division bench has said that granted LIC to make an application before this court.
No, with the liberty, my lord, kindly have a look.
Let us come back, call back.
Yes, my lord, kindly. Yes, I'm grateful. I'm grateful. My lord, page 29, my lord, kindly have a look.
permitted to withdraw the
Kindly have a look. During the course of hearing, my lord, this is very important. Learned counsel for the parties reached to a consensus. It is agreed that the appellant may be permitted to withdraw these intra-court appeals, being so-and-so, preferred against the orders dated so-and-so respectively, with liberty to file appropriate application seeking modification of the said order based on the judgment of Supreme Court. The other sides have no objection. The appeal stands dismissed as withdrawn with liberty as prayed for. It is made clear that this court has not expressed any opinion on the merits of the matter. So, my lord, I have got the liberty to apply. I have applied. Now, my lord, today, my lord, notice has been issued. Now, my lord, main writ will not be heard because matters pending before the Supreme Court. My lord, no, my lord, let me just, my lord, conclude this. My modification also will not be heard because the matter is pending before the Supreme Court and a notice has been issued. My lord, kindly say that.
No.
Then
Question
kindly
is the
kindly
same
just.
identical issue is pending before the.
That was the situation. That's the order.
This court will made an exercise to find to adjudicate the issue at this stage.
My lord, may I put it this way? I'm not asking your
Try
lordship.
to appreciate the predicament of this court.
My lord, kindly appreciate my predicament also. Kindly appreciate my predicament. My lord, I went up to the appeal court. What wrong, my lord, if I may ask myself this question, has LIC done? My lord, that's my submission in question form to you.
Order was passed on consensus.
Yes. Correct. My lord, before the division bench, the observation of the division bench when I took the point that Kusum ingots, my lord, is binding pan-India. On that basis, Allahabad High Court is binding pan-India. The court asked, did you say this before the learned single judge? Because before the learned single judge also, my lord, the ground for not, my lord, proceeding with the writ and passing the order was because, my lord, the specially petition was pending. There was no stay.
And there was an order of the division bench of our court also.
Yes, absolutely. So your lordships will now, Kusum has not been considered by any. That's why this liberty is given. My lord, there are several courses open. I cannot advise your lordship. But my lord, I have, my lord, come back, my lord, to press, my lord, the modification. My lord, if your lordship feels there's been a change of circumstances.
Since the leave is granted by the division bench, you press it.
Yes, my lord, that's all that I'm asking for. That, my lord, I'll take just 1 minute, my lord, to place.
Take your own time.
No, my lord, I am not.
Why should I confine your efforts?
My learned senior friend Willard has come up with an application for modification of an order 24 June 2025. I am told that a few weeks ago, Millard, a bunch of matters, Millard, that were taken up for consideration by your lordship on the similar grounds. Your lordship directed the matter, all matter should be posted after January or like this, let it be go out of list. That was the observation.
In view of pendency of
the pendency. Now, Millard, the order of modification, this is the modification application for modification of the order. I must get an opportunity to deal with it, number one. Number two, it is a consensus as to what extent my learned senior friend, client Millard, wanted to withdraw the appeal.
No. My learned friend wasn't even there. My lord, I think, my lord, my learned friend's junior should be, my lord.
Millard, why the appeal was withdrawn? Because my learned senior friend said that the Kusum ingot was not placed before the honorable single judge. This matter was this, sir. Order does not reflect when my learned senior friend, he has a standing at the bar, Millard, and he's a leading light of the bar. I take it as that it was
grateful.
considered. No, Millard.
I'm grateful for, my lord, him accepting my submission.
No.
Not, my lord, calling me, my lord, a leading light. My lord, I don't want to be a leading light.
Dispute things.
No.
Nobody dares, Millard. But I should get an opportunity to deal with Mr. Mukherjee, my learned senior friends, Millard, agony or affliction or anxiety centered around that except West Bengal, all other states have done away with this provision. The question is, Millard, the rule 2009, Millard, when the appointment letter was issued, it is a combined effect of 2009 rule and 1961. 1960. So, Millard, this selective amnesia while looking at the one rule and just ignoring the other, my lord, that is also selective understanding, my lord, which suits its interest, the client's interest, my lord. Today, my lord, he has come up with an application for modification. Today, my lord, in this judgment, my lord, the Supreme Court has also said in 2025 SCC on line, the Kusum in God, a parallel judgment that 2025 SCC on line 2325, I read for my lord. Yes. But the question is, my lord, I must get an opportunity. Because the rule says that I have some right. What is the disciplinary angle? What is the element of misconduct? Suddenly that LIC failed to secure business. Under what circumstances? His client has not
want to file affidavit.
Yes.
My lord, I am, my lord.
Kindly extend the interim order and permit us to file the affidavit.
Extend.
Interim order is
Extend for
there. Interim order is
Then, my lord, may I, my lord, just, my lord, make, my lord, one respectful submission. I am not going on facts at all because, my lord, the interim order also did not go on facts. It refused to touch the writ petition because the same issue is pending before the Supreme Court. Now, my lord, Allahabad High Court, my lord, judgment also I'm not placing because it's accepted that it is, my lord, held that it's intra vires. I am only on the effect of that. If ultimately, my lord, the effect is because notice has been issued, your lordship feels more time should be given, my lord, that's the end of the matter. So, my lord, my respectful submission is kindly consider just Kusum in Gods. I'm not going to take any more time. Learned friend wants to distinguish, he can distinguish it. I'm not going to, my lord, there's no factual issue involved here at all. Because, my lord, factual issue, the court has said it will not touch because the issue is pending before the Supreme Court. So, I'm not going into it at all. I'm saying exactly what I told the division bench. This order was passed. We made a mistake. We didn't cite Kusum. So
then why the appeal was taken back, was withdrawn?
Judge requested me, my lord. Everybody was there. We could have kept it pending. We'll go up, my lord. After this on, need not go up. If we succeed here, we need not go up.
So
that's all.
Since the other side is petitioners, from petitioner side, the prayer is made for filing an affidavit. Let us short deduction.
My lord, yes, this is, my lord, great, my lord, tactic by Mr. Kollol Bose because there's no fact involved. There's no fact involved. No, my lord, my application for modification is based on Kusum in God. I've just said that. I've said so in my application.
No, court may incline to consider the facts during course of hearing of your application.
Yes. Now, my lord, the court has said it will not consider the facts. That's the first order of which what am I seeking modification of? Only the second line. Court has said I will not touch this writ petition. Kindly have a look at that order.
Order dated 18th August 2025.
No. 25th April 2025.
Passed by the court.
Page 22. Page 20. Page 24th June. Kindly have a look. What is happening? 24th June. Kindly have a look, my lord. My lord, after reciting what is happening in the Supreme Court, kindly take page 6. My lord, no interim order has considered the facts prima facie or otherwise. Kindly have a look. Third line. In view of the above, since the issue is pending before the Honorable Supreme Court, the judicial propriety demands that hearing of this writ petition should be adjourned for the time being until the issue is finally decided by the Honorable Supreme Court. So, my lord, writ will not be heard. We don't quote, there's not one word on the facts. Then, my lord, kindly see, the same interim order passed earlier dated can continue for the time being. Accordingly, the proceeding against the petitioner may continue, but no final order shall be passed by LIC. This is, I'm saying, I'm happy with the first portion. Writ will not be heard because that's the law. If an issue is pending before the Supreme Court, court should not touch the writ petition. I am only saying I should have shown Kusum.
But now, in view of the order passed on 24th of November, entire exercise before this court is academic now. Because ultimately it will depend upon the outcome of that SLP, Mr. Mukherjee.
My lord, correct. Now, my lord, if the order is, my lord, if the last portion of the interim order My lord, which is,
Mr. Mukherjee approached the Supreme Court with an IA.
my lord, unless
With an
there is,
IA instead of approaching this
my lord,
court.
unless there's a appeal is admitted, I have not approached. The writ petitioners have approached. They could have filed an IA.
The division bench.
No, they,
You have
no,
approached
no,
the division
my lord,
bench.
my lord, they could have approached, my lord, the Supreme Court rather than filing a
They
writ.
are protected by the order of the coordinate bench.
Specially, petition was pending then also.
Yes,
Yes.
considering the pendency of the
Yes.
special petition, the coordinate bench has
Correct.
protected him.
Yes.
So, being agreed by this order,
I've
you should
gone
have
to-
approached the
No, no,
Honorable
my lord.
Supreme Court.
My lord, I think I've advised my client correctly because what transpired at the hearing was this issue raised before the learned single judge. The division bench.
Then Mr. Mukherjee let it be decided on affidavit, as Mr. Basu
My
is
lord,
praying for.
my lord,
Sorry.
my lord, kindly let me place Kusum in God's.
I'll permit you at the final hearing stage.
No,
Not
my
not
lord,
to-
kindly, my lord, I'll just show one paragraph. Kindly, just one paragraph. Then your lordship, my lord, decides. And my lord, kindly, my lord, may I make a request? If your lordship's that much against me, kindly, my lord.
No question.
No.
I'm
Kindly.
just expressing my
No,
mind.
your lordship's right. So, my lord, after citing Kusum, if your lordship, my lord, instead of affidavits, kindly dismiss my application if your lordship's still against me. On whatever grounds, my lord, I can't advise that because I don't want to be then later told, oh, well, the matter's now pending before the single judge, learned
Still,
single.
Kusum ignores what will come to the mind of this court. That court cannot assure you at this stage.
No, I'm
Yes,
not
yes.
saying. I'm saying in
Yes,
case.
Mr. Mukherjee, please place it.
Yes, my lord, kindly take Kusum in God's, my lord. My lord, kindly see, my lord, paragraph 21. দিয়েছো কপি দিয়েছো কপি কোথায় আছে
Yes, it is there.
My lord, kindly have a look at para 21. My lord, page 261. A parliamentary legislation, when it receives the assent of the President of India and is published in the official gazette, unless specifically excluded, will apply to the entire territory of India. If passing of a legislation gives rise to a cause of action, a writ petition questioning the constitutionality thereof can be filed in any high court of the country. It is not so done because a cause of action will arise only when the provisions of the act or some of them which were implemented shall give rise to civil or it should be civil consequences, not evil consequences to the petitioner. A writ court, it is well settled, would not determine a constitutional question in a vacuum. The court must have requisite territorial jurisdiction. An order passed on a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view the provisions contained in clause 2 of article 226 of the constitution, will have effect throughout the territory of India, subject of course to the applicability of the act. My lord, I rely on that. Then my lord, that's all.
But if these two paragraphs, there are observations, but whether the issue or the fact was akin to the facts which is being considered by this court today.
No, it wasn't LIC.
Tendency of the
It wasn't LIC.
identical issue or similar issue before
Yes.
the Honorable Supreme Court.
Yes, now my lord, similar issue if it is pending, the judgment.
Because the judgment of the Honorable judgment of the Allahabad High Court was challenged before the Honorable Supreme Court.
Yes, that was the first.
SLP,
That was the first order also. It noted, my lord, that it's under challenge. In fact, for your lordship's kind convenience, my lord, I have also, my lord, this order which I should point out. The last order on those, my lord, bunch of special leave petition. And the matter is fixed on 20th January.
This, the matter which was considered by the Supreme Court on 24th of November.
Yes, my lord, kindly see the date, my lord, 24th November. The order, my lord.
Yes.
24th November. It's the same matter.
Same
And
matter.
for completeness sake, my lord, my lord, here, my lord, show me the judgment of the Supreme Court will, matters pending before Supreme Court, it will not touch. My lord, there's, and apropos what fell from your lordship, my lord. The judgment says Supreme Court.
Yes, situation as it appears to me, I'm just expressing my mind.
No,
Mr.
no,
Chairman,
yeah, I know that, man.
That in a situation, court is considering this Kusum ignorance as observed in paragraph 21
Yes.
and 22, that when on similar issue, the matter is pending before the Supreme Court.
Yes, now, my lord, kindly, my lord, have a look at. Your lordship's absolutely right, my lord. That issue was not, my lord, there in Kusum ingots.
Right.
Yes, so my lord, if now that issue is there and a notice has been issued, now, my lord, kindly have a look at 1986 supplement SCC 20 at para, my lord. This is whether, my lord, varies whether there is an order of Allahabad High Court or not. Now, my lord, kindly have a look at paragraph 83. Page 78, my lord. এটা রেখে নাও, হারিও না। সব অন্য মামলায় লাগবে। My lord, kindly see para 83. Civil appeals so-and-so are directed against the order of the Gujarat High Court, dismissing writ petitions filed by the appellant challenging the constitutionality of so-and-so and the validity, and directing the appellants to approach the Supreme Court as similar matters were pending there. In our opinion, the course adopted by the High Court was not correct. If the High Court thought that the point raised by the appellants was the same as was pending in this court, it ought to have stayed the hearing of the writ petition until the court disposed of. As we have, however, held 15 amendments to be valid, both these appeals are therefore dismissed. Court should not have touched it at all.
That is what your lordship has done.
Without interim order. Because you can't touch it. If you can't touch the main petition, you can't pass an interim order.
The final order has not been
No,
passed.
interim order.
Interim order is not passed, then the writ petition will become infructuous, Mr.
No. Once the order of the Supreme Court comes, rights can always be worked out. It's not infructuous at all. It's
After
not.
termination and everything.
It's not
what
infructuation
will
at all.
remain?
My lord, of course they can be reinstated. It's done regularly.
Who will assure this guy? Who will assure us?
The court will ensure that.
That is subject matter final hearing. It is on a contested hearing. The LIC has, my lord, contested this proceeding with passion. Now, my lord, the interim order was passed that I did not obtain this interim order, my lord, behind their back. Number one.
No, nobody
Number
said
two. Number two. What are the principles, my lord, that the guiding factors, that when the court should modify its own order? Because, my lord, there is no misrepresentation, there is no fraud. And this is a passing observation. I have two judgments to cite, my lord. Let my learned senior friend, my lord, complete.
I concluded.
Because I want to, I concluded. Oh, then, my lord, there is a line of judgment, my lord, reported in 2025 SCC on line 2325. My lord, this paragraph 10. এই কপিটা দে তো একটা কপি আছে দুটো কপি এটা জজ সাহেবকে দিন জজ সাহেবকে দিয়েছেন আগে আরে গুড নামটা বলো We are deeply perturbed by the approach of the said Rahul.
Which judgment you are relying on?
2025 SCC on line 2325. Paragraph 10. We are deeply perturbed by the. Sorry. I'm sorry, Mirror.
Yes,
My lord, got it. Yes. We are deeply perturbed by the approach of the said such as Rahul, as well as the High Court of Uttarakhand, when the said Rahul was continuously following the proceeding before this court and was aware about the oral observation and the orders passed by this court, nothing prevented him from intervening in this proceeding if he was of the view that any of the orders passed by this court or any of the observation made by this court prejudiced him. However, in the teeth of the sanction which was granted during the pendency of the proceeding before this court, approaching High Court to challenge an order virtually amounts to interference in the present proceeding. The High Court, no doubt, is a constitutional court and not inferior to this court. However, in the judicial matter, when this court is seized of the matter, it is expected of the High Court to keep their hands away. That is what Mr. Mukherjee, my learned senior friend, had interpreted paragraph 83 of the earlier judgment. Question is, when the matter was contested passionately and the interim order was passed, and in series of writ petition, the interim orders were passed by the different court, the honorable judges, have applied their lordship's mind and lent their ears to the respective parties in the proceeding and passed this interim order. Now, kindly conceive a situation if the interim order stands vacated. What is the actual prayer? Now, interim order can be vacated only in certain circumstances. When there is a misrepresentation, when there is a fraud, when the materials suppression of material facts in order to gain something which is not legally correct. But question is here we are fighting this cruel combat only there are two issues: whether these rules permit the LIC authority to proceed in a manner which the courts they have adopted. Our respectful submission before this court, if your lordships, I will place Brajanath Ganguly versus Inland Water Corporation, it is an unequal, it's a contract between lion and the lamb. Suddenly LIC said that this is a business loss that has been incurred, alleging that we are responsible, the development officer. The question is what are the schemes floated by the LICs to the market? With their failure to compete with the other private players in the market, whether I should be liable for this loss, number one. Number two, what is our role? What is the financial assessment? What is the decision taken at the highest level? In a service jurisprudence, an employee can only be terminated when there is an element of misconduct or it attracts a disciplinary proceedings. It cannot be like a private master servant relationship that I hired you, don't perform, get out. It is not a mere contract. It is
what is the relevant provisions in the 2016 rules 2016, which is the virus of which has been questioned, based on which show cause notices were issued against the development officers like petitioners in the present case?
rules is at page 119.
Just
and show
in the writ petition 119.
Yes, and show cause
just
তোমায় অ্যাসিস্ট করে দিই
119 হচ্ছে আপনার এটা রুলটা Ministry of
ঠিক তুমি
in most of the cases in this court has found that the show cause notices have been challenged on the angle of this new rules of 2016.
Now, this Munmun Noshkar petitioner, she was slapped with a notice dated 30th January 2014. We have completed almost 13 years of our services. Now, suddenly they said your service is no longer required. Now, kindly see the language.
Where is the show cause notice?
First show cause, ওটা আলাদা rate.
Just a minute.
Second show cause is 25th March 2025.
If your lordship wants us to address on merit, then kindly fix a date. I thought the modification application on this court, because the High Court, while passing the interim order, the Kushumin got, according to our understanding, subject to what my lord say, it is a passing observation. It is not a decision on merits. Now, also in this case also, when this order was passed, High Court does not lose its power so far as the grant of interim order is concerned. The High Court has applied its mind, and it is not a clog or a barrier imposed by the Supreme Court They don't
No, in
hear.
order to appreciate the application taken out by on behalf of LIC, court wants to know the facts in a short campus, nothing else.
Yes. Milord, the show cause.
Why court will enter into the merit at this stage?
Yes, that
Because
is
the
why
application
I
stage,
thought, Milord, he has
court is
inquired. Yes.
considering the application of the LIC. Because Mr. Mukherjee has taken a specific point based on the judgments.
Kusuming gods.
No, 1986 supplement Supreme Court.
Yes.
Paragraph 83, that the option which is left to the High Court is to stay the hearing of the writ petition.
That is what.
So, in order to consider this judgment
Stay
and the
of hearing
observation,
means that
the court finds that what are the facts which requires interim order.
Yes, Milord, I got
That's
your
why I'm asking you.
Yes, 139 is the answer to your lordship's query subject to correction, Milord, 25th March 2025. It is an address to my client
Where?
to 139, annexure P5.
Because previously I have not heard this writ petition.
Yes.
This writ petition. That's why I'm asking.
Yes, Milord, my lord's query, Milord, my lord desire is a comment, Milord. I'm bound to answer.
(139).
Yes, my lord. Subject to correction. Your performance for the appraisal year ended on such and such has been assessed as under expense limits, prescribed expense limit, eligible premium, annual remuneration such and such. Cost ratio for the relevant appraisal year on the basis of the annual remuneration such and such. C1, by the application of the provision contained in sub-rule 1 of Rule 6 of the LIC such and such, amended as Life Insurance Corporation of India Development Rules of certain terms rules for the appraisal year ended on February 25. Your basic pay has been fixed at minimum of basic pay applicable to the development officer on second occasion.
Basu, I once which necessitated this court to pass an interim order in a short campus.
Milord, necessitated means
you are not ready, then address me on the next date.
Yes. Milord, next Monday.
Manner of submission you are making, it appears to me that you are not ready with
I thought, Milord, the application for modification would
you did not expect that Mr. Mukherjee will wrap it up within such a short time.
Yes.
My lord, I'm just keeping my promise before the division bench. I said I'll only cite one judgment.
Only, Milord, I thought, Milord, the application for modification, I tell your lordship, my anticipation, many a times it fails, Milord, because first of all, Milord, I feel certain neurological disorder when I confront him in the mercurial combat because his cerebral alacrity is unmatched, Milord. I cannot match with him.
Very well. So come ready.
Yes,
in a short campus, you address this court that what necessitated this, the coordinate means to pass an interim order. Because it is relied upon a judgment of the Supreme Court, paragraph 83, that the course which is left open otherwise is to stay the hearing of the writ petition.
Yes.
So therefore, in other words, Mr. Mukherjee has made a submission based on paragraph 83 that not to pass an interim order, not to touch the writ petition till the issue is heard before the Supreme Court. So which prompted the coordinate bench to pass an interim order. To that extent, I want an answer from you. Try to understand the nature of query of the court.
তুমি যেদিন থাকবে করো
10th no 12th বাইরে একটু যাবো
কি করছো আমি আছি বলে যত অ্যাডভান্টেজ নিয়ে যাচ্ছে
আরে আপনার সাথে লড়াই করাটা তো আমার
কল্যাণ বন্দ্যোপাধ্যায় থাকলে নিতে এগুলো
এটা কিন্তু বাজারে যাচ্ছে
12 there is a application date. For Friday there is difficulty. Because contempt and applications are taken up on Friday. So it is an application which will take some time.
Then 16th possible.
Mr. Mukherjee, do you have any difficulty?
My lord, I'm always. My lord, I can in fact also deal with this judgment straight away. Should I, my lord? It'll take 2 minutes.
No. It is not necessary. Let him complete.
Court's query is very limited.
Yes. Issue. Application being can. One of 2025 is taken up for consideration. Stop. Mr. Mukherjee, Mr. Shaumendranath Mukherjee, learned senior advocate representing applicants / Life Insurance Corporation of India has made submissions. Stop. Mr. Kollol Bosu, learned advocate representing writ petitioner, has also made submission, but hearing is not concluded. Stop. List the application for further consideration. On 16 December 2025.
May I make one request? Item 41 is identical modification. There were two matters before the division bench. Let it be, my lord, listed together, my lord. Item 41 in your lordships. चढ़ा तो तुम ही नहीं, तुम्हारे दाई नहीं होगा.
16 under the heading application on 16th December 2025, along with just 41, along with WPA 11664. 41 is room 44, along with another writ petition being
item number 44, my lord, item number 44.
Along with another writ petition being WPA 1340 of 2025, comma, Proloy Patro versus Union of India and others. Stop. Mr. Mukherjee, learned senior advocate, has submitted that the writ petition being WPA 1340 of 2025 relates to similar issue.
Deeply obliged.
16th, it
Yes.
will appear under the in the supplementary.
My lord, may I file the affidavit of service?
Yes, the affidavit service filed on behalf of the petitioner, on behalf of the applicants, is taken on record. হ্যাঁ, সাপ্লিমেন্টারি পরেরটা তো অ্যাপ্লিকেশন আছে, দেখে নিয়েছেন। It does matter.